Lordship, is a Capcom matter, Your Lordship, Mr. Bachawat, Your Lordship, on that occasion, Your Lordship, was only submitted, Your Lordship, that without evidence, Your Lordship, the matter can be posted for arguments, Your Lordship. Because we are not claiming damages, only for permanent injunction, Your Lordship has already passed judgments, Your Lordship, in without Your Lordship written statement, Your Lordship, if we are not invoking order 8 rule 10, if we are not, Your Lordship, invoking, Your Lordship, the damages portion, Your Lordship, the permanent injunction, Your Lordship, can be passed on that occasion.
That's correct. But on that day, it was, let me see if they will not bring the witness, then they will argue the matter. That's what this court has recorded.
It was posted the matter for undefended suit, and Your Lordship, no written statement has been filed. So that's why, Your Lordship, we sought for such this correction. If Your Lordship thinks fit, will come, Your Lordship will ready with the arguments and will do the arguments, Your Lordship.
Let it fix tomorrow for correction.
If Your Lordship thinks fit, otherwise Your Lordship will come back.
May I have Your Lordship's kind leave, my lord? This is item number 35 of my lord's non-commercial list. This is, my lord, that's parted and specially assigned partition suit, which Your Lordship had substantially heard. Only Mr. Chatterjee was to give his rejoinder. My lord, previously it was always time was fixed. Now I know, my lord's, it has changed, my lord. So anytime after vacation, this side of the vacation, I'll not trouble Your Lordship with the hearing matter. After vacation, my lord, any date convenient to Your Lordship, my lord, at 2 p.m. my lord. Only Mr.
The other side.
We have given notice, my lord.
Defendant number 2. 3 series.
Yes, defendant number 3 series, my lord. Mr. Chatterjee and Mr. Kormokar were appearing. This was on it was taken up on 5th of September. They were to, my lord, only they were to give their rejoinder. I understand, my lord, this side of the vacation is not possible. I'll not trouble Your Lordship, my lord. After vacation, any date.
Nobody is appearing for the 3 series because they have to give the reply.
Yes, my lord, they had to give reply. We have given them notice. Defendant number 2 is here.
Yes, my lord. Let it be. You are appearing?
2 is here. Only 2 is here, my lord.
Tomorrow has to be mentioned.
Tomorrow to be mentioned, my lord. Grateful, my lord. Deeply
Inform
obliged.
the other side.
Yes, my lord, I'll give notice again.
Yes.
May I have Your Lordship's kind leave, my lord, to mention, my lord, that ITC matter. My lord, my fault, I should have pointed out something. My lord, this is the order Your Lordship's passed. My lord, I am only suggesting, my lord, the portion in red, my lord, at page 15 of Your Lordship's order, my lord, so that there is no confusion. My lord.
Yes.
My lord, we'd like, my lord, an inventory and seizure, my lord. That's.
But that was not in the prayer.
No, that's why I said my mistake, my lord. I should have pointed it out, my lord. Your Lordship's absolutely right. Not Your Lordship's fault, my lord, our fault. My lord, I was praying for this to be, particularly, my lord, the portion, my lord, at times, my lord, they lock and go away, my lord, and my lord, they're inside actually, not go away, my lord, they're inside. My lord, Your Lordship kindly provides for that. And my lord, the next page, the 2 pages, my lord.
Yes.
My lord, subject to Your Lordship's approval, my lord, I'm just so that Your Lordship's.
But today,
yes.
Court officer ওখানে আছে তো নেই?
supplementary list आ जाए नहीं एक the matrix list and the matter suffering for the plaintiff and land counsel for the plaintiff has mentioned the matter for correction in the order dated 27 September 2024. This court considering the submission made by the counsel for the plaintiff, let the matter be appear in the supplementary list at 12 noon.
Obliged, Sir.
Lordship, may I have Lordship's kind leave to mention a matter? Lordship, in this matter, Lordship has been pleased to pass an ex parte injunction. Lordship, I have filed two applications. One is for vacating of the ex parte injunction and one is under Section 8 of the Arbitration Conciliation Act because the fact of the arbitration clause was suppressed from your Lordship. Lordship, the simple prayer is Lordship has put a injunction on the operation of the bank account, but Lordship, the basis on which your Lordship's order is premised that I am selling my property and the advertisement that was shown has nothing to do with me. I'm not selling my property at all. So Lordship, it is my humble submission that Lordship has possibly been misled by showing that advertisement. So if the application can be listed and I can move the vacating, Lordship, because it is causing grave prejudice to the...
What happened?
Open the collar, open the collar. Bend.
I'm all right, my lord. I apologize.
Take water. You take water, go. Take rest. Take rest and give the water. But file your application for vacating. It will be taken after vacation. Now there is a time to hear all this.
Lordship, it won't take a lot of time and Lordship has put an injunction on the operation of my bank account, Lordship,
When
which is
the injunction order was passed?
injunction order was passed on the 10th, but I have only been served on the 20th, Lordship, and
20th
immediately
of September.
20th of September.
Then
And I have passed, I have filed this as soon as possible after that, Lordship.
have you filed the application for vacating?
I have filed the application. The e-filing number is there, Lordship. The physical number I'll get
It
today.
is not possible for taking before vacation, sir. Come on the after reopening, you mention the matter, I will take that. You saw the copy to the other side, I will take the matter. There is no problem. But before vacation, it is.
I'm humbly praying, no, it won't take a lot of time, Lordship. Because of
You will not take a lot of time. This court is having a lot of work.
and I appreciate, Lordship, but
Sir,
I am also in
other
difficulty to
comment-
run my business because of the injunction
Because
order.
so many matters I have not taken up for the specially fixed matter, you cancelled it because of the all interim orders and all these things.
Very well, Lordship.
Yes.
May I mention before your lordship, my application upon notice, I am tentatively for inclusion.
Inclusion mention after vacation.
My lord, written statement filed.
Huh?
Written statement filed.
Oh, when vacation after.
My lord, may I mention an application under Order 12, Rule 6, my lord, only for exchange of affidavits if it could be listed on this side of the vacation, because it's an admitted claim, only if the directions could be passed for affidavits.
When
I'm
it
for
will
the
be
plaintiff.
taken up
Lordship, any day before the vacation. Kindly, because
for the other side. Have you served?
no, the other side has not appeared yet. They have not even filed the written statement, but
Ah.
it is a clearly admitted part of the claim.
If the other side is not appearing and it is admitted part, you go with the undefendant suit, you reduce your
They
evidence.
filed a GA for extension of time to file the written statement and
Then-
better appearance.
Then
so
how
that
it can
is
be
the-
taken up for hearing if the other party has filed an application for extension of a commercial matter?
No, non-commercial.
Then
Lordship, this is the extension is with regards to filing of written statement. but
Correct.
My application is Order 12, Rule 6.
So-
If affidavits could be directed to
so
this.
what is the stage of the order that extension of time and
That
there's
has
an
not been heard out now.
there's an order of there is a direction for affidavit.
In that application, no, Your Lordship.
Then they will come, they will file, they say that they have filed an application. The both application come after vacation.
May I have your lordships kindly, my lord, to mention, my lord, this matter, my lord, is a undefended commercial suit. Lordship directed, my lord, filing of judge's brief of documents within 2 weeks from the earlier date of the order. And my lord, after 1 week thereafter, my lord, affidavit of evidence. My lord, the judge's brief has been filed. My lord, the affidavit of evidence could not be made ready. My lord, I am seeking leave, my lord, to file it now. My lord, the matter is posted on,
Returnable date.
my lord, 3rd of October.
Come on that day. With your
With ready, my lord.
come on.
Very
that
well.
day. If
But
time
I'll
permit
file
it,
it because, my lord, it has to be filed in the department. That is why, my lord, I
no,
seek the leave.
affidavit evidence, it will be taken here.
I am grateful to your lordship.
My lord, similar to the matter Mr. Mukherjee just mentioned, a suit has been also filed, my lord, for protection of the trademark gold fleck. We have filed the suit. I am, my lord, only beseeching my lord leave to, my lord, present the plaint and, my lord, also move the application for
Where is
injunction
your
tomorrow.
plate?
It has filed. It's in the. May I, my lord, present it tomorrow and also, my lord, leave, my lord, to, my lord, move the application.
Come, let it be listed, then we'll see to
Yes,
that.
my lord, what we leave really require the leave for is, my lord, because there's some urgency. The plaint has been filed. The department, my lord, won't accept, my lord, the filing of the injunction application unless it's presented. So all I am, my lord, beseeching is if lordship may kindly grant me leave to, my lord, file the application, my lord, before presentation of
What
the plaint.
application?
Application, my lord, for injunction and, my lord, similar orders.
See, you are filing the suit.
Yes, it's filed.
Along
It's
with
filed.
the suit, you are filing the
Yes.
interlocutory application.
Yes.
Where is the leave is required?
No, because my lord, the plaint is yet to be presented, my lord, to file the application before, my lord. Otherwise, department is not accepting it.
So there are 1 week is there. You file it tomorrow, presented,
Okay.
then after filing, you mention that we'll take that. There is no
Then
problem.
may I, my lord, beseech this? There, my lord, beseech this. May I, my lord, as unlisted, my lord, seek to, my lord,
What is the brand?
gold fleck.
Gold flag.
Capstan was, my lord, around 2,000 crores. This is, my lord, even more.
Then
My lord, is the urgency is, my lord. We just came to know, and this is, my lord, the tomorrow, my lord, any time.
first you bring your suit, let the
Lordship.
suit be admitted, then we'll see.
Lordship.
Let you
May I,
bring-
my lord, then present the plaint, my lord, at
let
tomorrow.
present. No problem.
Tomorrow, and my lord also.
If it is
application to
listed, then
ready
we'll
the
take. There will be no problem.
lordship. And may I, my lord, also subject to my lord lordship's the kind leave. May I also try to, my lord, move the application immediately after presentation of the plaint.
Then first your plane should come
Lordship.
before this
Lordship.
court.
Lordship.
Yes, next.
Lordship. Grateful.
My lords kindly to mention, lordship, it's a correction of the order filed by lordship on 25th of September. Lordship, it will be Miss Hati Agarwal appearing for the plaintiff, not for the defendant. Thereafter, the prayer made by the counsel for the plaintiff.
You are appearing for?
For the plaintiff, lordship.
Not the defendant.
No, lordship. Mr. Tiwari was appearing for the defendant.
It has been, who has given the name in the state?
This is it. The appearance is correct, lordship. The appearance given is absolutely correct.
Petitioner in?
Petitioner in the suit. It should have been plaintiff actually.
Who? Mr. Sailendra is appearing for whom?
For the plaintiff.
Plaintiff. You are appearing for
the plaintiff.
Both are appearing.
Yes, lordship.
Nobody is appearing for the defendant.
Lordship, Mr. Moti Sagar Tiwari was appearing for
On
the
that day,
defendant.
anybody had appeared?
Yes, he was appearing, lordship.
For correction. Yes, next.
Obliged, lordship.
My lord, I am for the respondent number 1 and 2, my lord. On the last occasion, my lord, I prayed before your lordship that I want to replace the written submission filed by me, my lord. Earlier, I have filed, my lord, there are some typographical errors, and so, my lord, I want to replace it, my lord.
Who is for the other side?
Your lordship, I am appearing for the appellant.
Yes. Have you served?
No, my lord, my copy is ready. I shall serve, or if they are.
Who is your advocate on record, madam, here?
Your lordship, it's Abhiroop. I'll ask for the arrangement. We'll today exchange the copies.
Tell your advocate on record. She will accept. I am fixing after vacation for hearing.
Yes, your lordship. The earliest date, your lordship, is possible.
May I take back the earlier one, the written submission filed by me earlier one? May I take back, or
that will be record? I will when you file the earlier written statement.
Long back, my lord.
Census when suffering for the applicant, census when suffering for the respondent number 1 and 2, full stop. On earlier occasion, do not put the date. On 22nd of July 2024, the respondent number 1 and 2 have filed their written note of argument, but subsequently, the respondent number 1 and 2 find that the written statement is to be corrected. Accordingly, as per the leave granted by this court, the respondent number 1 and 2 have filed a fresh written notes of submission, a written submission on behalf of the respondent number 1 and 2 after serving the copy to the learned counsel for the applicant. Let the same be kept with the record. Please the matter.
If your lordship may fix a date and time, it would be, we could finish the matter actually. It's very short time.
It will be difficult. I am fixing a short date. I am fixing a short date.
Yes, your lordship. Much obliged.
On 11th of November, under the heading adjourn motion.
Much obliged.
I'm gonna let them also supply a copy of written.
Yes, Your Lordship. We'll supply our copy also, Your Lordship.
Get
Yes. Who is there? Yes,
But I am for the respondent.
respondent.
Defendant did not serve the copy.
Milord, may I address the Lordship? Milord, GH3 is my application. I'm the defendant in this suit. This is my application for extension of time to file the written statement. If your Lordship remembers, my Lord, in this matter, there was a confusion about whether we filed it on the 120th day or the 121st day. My Lord, there are two things here. Firstly, my Lord, I must confess, service is not complete. My Lord, kindly allow us to serve the other side. Secondly, my Lord, my advocate, my Lord, in his personal capacity, will file an affidavit, my Lord, to narrate certain events which transpired on the 120th day, to show that we actually filed on the 120th day, even though the acknowledgement was given on the 121st day. My Lord, so we'll also have to put in an affidavit. Kindly, my Lord,
Matter is listed as to be mentioned on the report of the department. There are three things are there. Department has
yes,
given the report. That's why your application has not been registered. One thing, the leave, this court has granted leave to you on 3rd of September 2024, but you have filed the master summon in the department on 11th of September.
Yes, my Lord.
11th of September. One. Second thing, Wakalatnama and affidavit of competency has been filed in the department on 4th of September instead of 3rd of September. Third is that on 7th page of the petition, a correction has been done without any initial of the commissioner of oath or affidavits. These are the three things is to be done. So once the court is given a liberty to file, you will not file on 3rd. Then you file the Wakalatnama on the 2nd day. Then there are a correction. After the affidavit, you made a correction. There is no initial of the commissioner. What can be done in your application? Tell me.
My Lord, insofar as the correction is concerned, my Lord, that will be done. That is the defect, my Lord, that we can comply with. This, my Lord, wasn't, there were 5 defects listed earlier, out of which, my Lord, 4 had been cured. This now, my Lord, appears to be, my Lord, a new defect. So, my Lord, this we will.
But this court has granted leave. This court has granted leave to file on 3rd, but you file on 11th. So how the application will be taken on record?
My Lord, I will, may I, my Lord, submit. My Lord, on the 3rd, your Lordship granted us leave to file both the written statement as well as the application for extension of time.
Correct.
My Lord, both were attempted to be filed on that day. In fact, my Lord, the written statement was also affirmed on that day. On an affirmed copy, your Lordship endorsed leave. When, my Lord, we went to file with the Wakalatnama, the Wakalatnama was also dated 3rd. When we went to file, the department, my Lord, raised an objection with regard to the, my Lord, supporting board resolution, which was annexed to the Wakalatnama. That wasn't, my Lord, in appropriate form. As per the department's opinion, they asked us to carry out some changes in the board resolution. Because of which, my Lord, now, my Lord, the client had to then arrange for a new board resolution. Each person, my Lord, again had to sign. So, my Lord, this took 1 day. So the Wakalatnama then was filed on the subsequent day. But, my Lord, my argument is that when a Lordship granted leave, if there were any defects, if there was any impediment from our part, the least that they should have done is acknowledge the fact that we tried to file it on the 3rd. And they should have accepted it subject to certain objections being recorded. And then we would have replaced the board resolution in the Wakalatnama. We would have done the other things which were required. But the department didn't even give an acknowledgement on the 3rd. We were hoping that on the 4th, when they give us an acknowledgement, it would at least specify that the filing happened on the 3rd. But even that has not been done, which is why it's for an imperative for my advocate on record to put these things in his own affidavit. The fact that he was there in the department on the 3rd, the fact that he was filing it on the 3rd, but no acknowledgement was given. But I can't be put to prejudice because of the department being rigid.
To be mentioned on the report submitted by the master in charge. It is found that this on the prayer made by the counsel for the defendant. Defendant, you are appearing for the defendant. Yes.
I am for the defendant. My Lord, may I just point one more thing? My Lord, your Lordship had
yes.
My Lord, your Lordship had summoned the master, and your Lordship had personally summoned me, my Lord, as counsel. My Lord, I was before your Lordship, the master, your Lordship heard us, and then your Lordship directed the master to clarify and endorse that even though the filing was initially done on the 3rd, but defects were subsequently complied, and that way your Lordship had, my Lord, given a narrative to be written. But I don't know if the report contains that narrative as per the directions of your Lordship. I cannot vividly recall. In fact, it would be on video as well. Your Lordship had directed the master to record that on the third we had filed, but then there were defects, so the defects were complied subsequently at a delayed stage. This, my lord, was clarified by my lord in this matter. Your Lordship will kindly recall.
For the defendant, on 3rd of September 2024, this court has granted leave to the defendant to file a to file an application for extension of time to file return statement. Full stop. The defendant, full stop. As per the report, it is found that the as per the report, it is found that the defendant has filed the master summon along with the application on 11th of September 2024 at 2:30 p.m. The report also reveals that the defendant has filed wakalatnama and affidavit of competency in the department on 4th of September 2024. It was also mentioned in the report that in 7th page of the petition, a correction has been made which does not contain the initial of concerned commissioner of both of affidavits. When the matter is taken up for hearing today, the learned counsel for the defendant submitted that the wakalatnama and affidavit of competency was taken to the department for filing on 3rd of September 2024, the department has pointed out the defects and as such the same was not accepted, and after curing the defects, the same was filed on 4th of September 2020. Counsel for the defendant further submit that as per the leave granted by this court, the defendant has also affirmed the affidavit of the written statement on 3rd of September 2024. He further submitted that with regard to the correction in page 7 of the petition, he will take appropriate steps. Heard the learned counsel for the plaintiff, for the defendant, peruse the report. This court finds that the defendant has taken the leave from this court, but has not filed the application on the date fix, and as per the report, the wakalatnama was filed on 4th of September 2024 without the leave of this court. Thus, the application filed by the defendant on 4th of September 2024 cannot be accepted. Next, call.
Perhaps, my lord, this is appearing mistakenly, my lord. The subsequent order dated 10th September, it has been made returnable on December 10th, my lord.
Yes, 10th December. 10th December. Next.
Lord, 4 I appear for the plaintiff. My lord, on 9th of July 2024, my lord had directed for substituted service. My lord, the English newspaper was selected as, my lord, Times of India, but my lord, the Marathi newspaper was selected as Vasi Samachar. This we couldn't locate. So, my lord, our clients have given instructions with respect to two newspapers, my lord, which is Hamara Mahanagar and Nav Bharat. So I'll be praying, my lord, that either of the two newspapers, my lord, may be selected or both may be selected.
So English you completed now?
English, my lord, we are waiting for the. My lord, the both newspapers may be selected for Marathi.
Not English.
No, English is fine, my lord. English, my lord, I'm asking for change of newspaper in Marathi.
What is the name?
Your lordship has recorded Vasi Samachar, and my lord has also recorded Hindi newspaper. Actually, it should be Marathi.
So the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. By an order dated 9th of July 2024, this court granted leave to the plaintiff to publish the gist of the notice of the writ of summons in the English newspaper as well as in Marathi newspaper, but it has been inadvertently recorded as Hindi newspaper. Full stop. This court has directed the plaintiff to publish the same in the English newspaper, namely Times of India and Marathi newspaper within bracket karo wrongly recorded as Hindi newspaper within bracket wrongly recorded as Hindi newspaper Vasi Samachar. Full stop. Counsel for the plaintiff submits that there is no paper of Vasi Samachar.
Lord, we couldn't locate. There might be, but we couldn't.
Could not locate the newspaper published in the Marathi as Vasi Samachar, and he submitted that he may be allowed to publish the notice in the Marathi newspaper, namely
Lord, Hamara Mahanagar or Nav Bharat or both, my lord.
Hamara Mahanagar and Nav Bharat. Police. In view of the submission made by the counsel for the plaintiff, so plaintiff is the order dated
9th July
2024 is modified by allowing the plaintiff to publish the notice in the English newspaper Times of India and Marathi newspaper, namely Hamara Bharat,
Hamara Mahanagar and Nav Bharat. And Nav Bharat.
This order may be incorporated with the order dated 9th July 2024.
Just, my lord, may it be my lord's pleasure, my lord, to also include Marathi as well as Hindi. If we find, my lord, we shall do it.
The plaintiff is also directed to publish the notice in the Hindi newspaper, namely Dainik Jagran. What?
I don't have the Hindi newspaper. Your lordship may kindly gives.
I don't know whether the Dainik Jagran or what is in Maharashtra. Why you are not doing the complete homework and making the submission before?
No, my lord, I was prepared with Marathi, but my lord, since if they come with this plea that Hindi newspaper is also, that is why, my lord, I am asking.
Marathi news. See,
just if my lord gives me permission.
Navbharat Times is also like the Hindi.
My lord, Dainik Bhaskar.
There.
Dainik Bhaskar is a nationwide.
Where it is?
My lord, Maharashtra.
Dainik Bhaskar, I don't know. Navbharat Times.
Not any newspaper, my lord.
Also Hindi newspaper, any of one of the Hindi newspaper, yes, which is widely circulated in Maharashtra.
Extremely grateful, my lord.
This order may be incorporated. Next.
Number 5.
Item number 5, your lordship, I am for the plaintiff.
Lord, I am for the defendant, my lord.
Insurance claim, your lordship. So, lordship, the inspection completed. Admission denial, your lordship, we have exchanged. Admission denial for the plaintiff, we have filed. Proposed issues, your lordship, we have circulated. And I have already filed the proposed issues. And one application I have filed for appointment of advocate commissioner, your lordship.
My lord, so far defendant is concerned, my lord, we are also filing the admission and denial of documents affidavit and also the issues, my lord. So far the issues are concerned, my lord, that has to be framed by your lordship at the first time. As I understand that in case of 4, 5, 6 of our issues are same to that of 3, 4, 5, 6, 7.
Plaintiff issues, your lordship, we have already filed.
Issue. What is the suit for?
Suit is for, yes, your lordship, insurance claims, your lordship. There is a repudiation of your lordship, the insurance claim, and that's why, your lordship, we have filed the suit.
So 3 and 5 overlapping.
My lord,
of the plaintiff.
Yes. 4, 5, 6. My lord, 4, 5.
I am coming one by one.
Yes.
3 of the plaintiff and 5 of the defendant. Can you see the 3?
And 5 of the defendant.
Yes.
That is overlapping.
Yes.
So I am taking the 3 of the plaintiff.
Yes.
Then 5 and then
এটা ঠিক আছে, দুইটা আপনার ওভারল্যাপ করছে, এইটা শুনে 2 and 4 your lordship is overlapping, my 2 and his 4.
Valid, yes. So 2 will take, then 4.
Yes.
Plaintiff is entitled to the insurance claim of whether the claim of plaintiff action to 16 lakh together with
repudiation টা হয়ে গেছে তো?
এই সার্ভে করে 27 জুলাই 22 কি 21 দেবেন এবার।
So the defendant 6 is defendant, you are 4, plaintiff's 4.
Mine 4 and there your lordship 6. Rather 4 and 5 and they are 6.
6.
Or rather 4, 5, 6 and they're only 6.
Yes.
4, 5, 6.
And they're only 6.
So their 6 will be taken. Your 4, 5, 6 will be deleted because you are segregated.
Yes.
And he has given a
Yes,
combined
yes.
as per the prayer of.
Right.
Lordship, if my 4 can be considered because they have said to the extent of 16 lakh and mine is 83 lakh 68,054.
16 lakh 83,000.
Along with interest.
Along with interest for some 83. Along with interest with 5 crore. 5 lakhs. What is this?
Just 50 lakhs. Your lordship, damages is for 50 lakhs.
It is their claim, my lord.
Yes, yes.
Plaintiff's claim.
So okay, your 5 and 4, 5, 6 has been taken.
Yes, your lordship.
So 6 defendant 6 is deleted.
Yes, your lordship.
The plaintiff is entitled to any other relief. Maintainability could go contractual relationship until
1685.
you are 7 and defendants 3. 1, 2, 3.
Yes.
That will be taken.
And only
Yes?
one correction
Well,
your
the
lordship is required.
first one, so far the first one is concerned, this is a prima facie situation where the suit is maintainable, my lord.
I am taking that.
Yes, yes.
You are 1, 2 and 3. Defendants 1, 2 and 3 I am taking that.
Well,
And
then other things are covered.
Only one correction, your lordship. Issue number 2, the date should be 27th July 2021.
It is correct in the issue framed by the defendant, my lord.
ठीक है, we can say date change for.
so and suffering for the plaintiff, so and suffering for the defendant. Counsel for the respective parties submit that. Discovery and inspection of the documents have been completed and have filed their respective affidavit of admission and denial of the document. Let the same be kept with the record. Both the parties have filed their suggested issues. Considering the submission made by the counsel for the parties, for use the suggested issues and the pleadings, this court frames the following issues. This 1, 2, 3, defendant 1, 2, 3.
অ্যাপয়েন্টমেন্টটা করিনি।
Only 3.
Market.
Let the matter. So the
Lordship,
plaintiff
my
has-
application is also ready. Lordship, may I file your lordship the judge's brief? I've prepared everything.
Have you solved?
Yes.
Plaintiff has filed the judge's brief of document containing how many?
Lordship, total it's 1, 2, 3, 4, 5, 6, 7 volumes.
Containing 7 volumes. After serving the same to the learned counsel for the defendant, let
Sir,
the same be cut.
we require to be served, my lord.
Serving lordships. Right.
Let the same be cut with the record. The plaintiff has filed another application being GA Com 3 of 2024, praying for appointment of advocate commissioner to record the evidence of the plaintiff and the defendant. And the expenditure shall be borne by the party seeking. Yes, you have any objection? Appointment of
No, I don't.
But it should be expedited, not your case like that.
My lord, please do not. I'm so sorry on that date. But sometimes it happens, my lord. Sometimes witness gives a single answer after questioning 10 questions, my lord. This happens, my lord. Otherwise, we do not want to prolong it.
That is the commissioner has to tackle all these things.
But
Considering
Because nowadays, my lord, the persons are very intelligent, my lord. They know how to get out of the things.
considering the submission made by the counsel for the respective parties. Yes, any choice of your
Your
advocate?
Lordship, by consent, Your Lordship, may I suggest somebody's name because they are voluminous documents.
If both the parties are
Yes, Your
ready.
Lordship. I've shown him, Your Lordship, the name. It's a good gentleman, Your Lordship, sitting in Bar Library.
So is appointed. Give the phone number.
Yes, Your Lordship. Phone number.
Appointed as
The Malada.
Advocate Commissioner for recording of the evidence of both the parties on commission. The remuneration of the Advocate Commissioner is fixed at rupees 15,000 per sitting.
Per sitting, Your Lordship.
15,000 per sitting. The remuneration of the Commissioner shall be borne by both the parties in equals. The Commissioner is directed to inform the date of examination of the witness on commission to the Assistant Registrar of this court, so as to enable the official of this court to produce the document of the present suit before the learned commissioner for examination of the witness on commission. Full stop. How many witnesses you will have?
I have only one witness. They may have two witnesses, Your Lordship.
The commissioner is directed to complete the examination of witness on commission within a period of 4 months after puja vacation. After puja vacation. Full stop. The commission is directed to file the report on 4th of March 2025.
My lord, grateful.
I'm grateful, Your Lordship.
And GA3 is dismissed. For filing report by the commission.
Lordship, I have already served it, Your Lordship.
I record.
Yes, I'm grateful, Your Lordship. नामটা বলি নামটা কি
31. Yes.
Lordship, this is my suit, Your Lordship, for infringement and passing off. Your Lordship, these marks are, Your Lordship, really rally and really. And Your Lordship kindly sees
What
this.
is your original mark? Really?
No, my original mark is rally, Your Lordship. I am registered. The registration certificates, Your Lordship, I have already annexed. Lordship, kindly take page 87. I have a word mark registration.
87.
Page 87, Your Lordship, I have given the registration certificates.
Yes.
Page 87. Rally, device mark, class 99, Your Lordship, is a multi-class, Your Lordship, class 7, 8 and 11. Your Lordship, kindly sees page 88. Again, Your Lordship, multi-class, class 99, class 7 and 8. Mark rally, Your Lordship, is a word mark registration.
What is pump?
Is a, Your Lordship, agricultural, Your Lordship, pumps. Lordship, if Your Lordship kindly sees, Your Lordship, the similarity. Lordship, kindly take page 13. I have just given Your Lordship a comparative chart.
They are not having any registration. They are having registration.
They have a registration, Your Lordship. I have annexed, Your Lordship, that registration also. If Your Lordship kindly sees their registration mark, page 283. Lordship, second volume.
Really?
Yes, Your Lordship. We have filed a rectification application also against this.
Not opposed.
No, not opposed because we had no knowledge regarding that. And Your Lordship, user details, Your Lordship, kindly sees proposed to be used.
Oh, when it was?
And it was, Your Lordship, registered sometime in 2017, but thereafter we came to know, Your Lordship, sometime in, Your Lordship, July 2024. We immediately filed rectification. They also filed another application. We will make an objection to that. And there, Your Lordship, selling, Your Lordship, online as well as, Your Lordship, physical sale. That particular sale, Your Lordship, documents we have given. If Your Lordship kindly take page 355. 355. Within jurisdiction, Your Lordship, Yusuf Ali and Sons, 138 Canning Street. And Your Lordship, there are online sales also. Lordship kindly take.
They are selling all the brands.
Yes, yes. 346 online sale they are doing.
346.
Page 346. In India Mart, your Lordship, the products are available. So physical as well as your Lordship online sale, both are your Lordship they are doing.
What leave I put it for?
Lordship 3 leaves your Lordship because the defendant your Lordship is outside. So that's why your Lordship I'm praying for leave under clause 12, order to rule 2 and section 12 will leave.
The plaintiff has filed the present application for decree of perpetual injunctions against the defendant and allied prayers. The plaintiff submitted that the defendant is using the trademark of the plaintiff rally, rally as their trademark really, R-E-L-L-Y, really, which is the deceptively similar to the mark of the plaintiff. The plaintiff came to know about the trademark only in the month of July 2024.
Yes, sir.
July 2024. And
Pleaded your Lordship.
after the inquiry, the plaintiff had immediately filed the present. The counsel for the plaintiff submitted part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of the court, and accordingly has prayed for leave under clause 12 of the letter.
May 2024.
12 of the letter script. Yes, May 24.
May 2024. Paragraph 21, your Lordship.
May 24.
May 24. But thereafter, your Lordship, rectification, opposition.
May 24. क्या बोला लास्ट में? Prayed for leave under clause 12 of the letter script. Consider the submission. Leave under clause 12 of the letter script is granted. The plaintiff has also prayed for leave under Rule 2 of the Code of Civil Procedure and submitted that the plaintiff immediately has filed the present suit, and there is every chance that further cause of action may be arose, and the plaintiff may pray for further compensation against the defendant, and as such, leave under Rule 2 under order to Rule 2 may be required, is required. Consider the submission made by the counsel for the plaintiff, peruse the pleading. Leave under clause 2, Rule 2 is granted. The plaintiff has also prayed for leave under section 12 capital A of the Commercial Court Act 2015. Counsel for the plaintiff submitted in the month of May 2024, the plaintiff came to know about the act of the defendant who is selling the deceptively similar mark to the mark of the plaintiff, and accordingly, when the plaintiff came to know that the defendant has also obtained the registration mark really, which is deceptively similar to the mark of the plaintiff rally, R-A-L-L-I, and immediately the plaintiff has taken out the rectification application before the competent authority, and immediately thereafter the plaintiff has filed the present suit. He submitted the plaintiff has filed the present application for infringement and passing off, and as such, no purpose will be served for going for the mediation process. The plaintiff has also prayed for urgent relief. Consider the submission made by the counsel for the plaintiff, peruse the pleading. This court satisfied that there is an urgency in the matter and sufficiently pleading has been made in the present application with regard to urgency and for non-initiation of the pre-institution mediation process. Considering the above, leave under section 12 capital A of the Commercial Court Act 2015 is granted. The plaintiff is admitted subject to scrutiny by the jury. Next.
Item number 7, your Lordship, I am for the plaintiff.
Yes.
So suit for passing off. Lordship, I am the registered proprietor, your Lordship, in connection with Asha Maya, and your Lordship, I have applied for your Lordship the mark for registration of Ashu Maya. That is at page 39, your lordship, the application status.
What is the product?
The product, your lordship, is hand pump. Lordship, I have given your lordship the picture. Your lordship, kindly take once page 40.
40?
40. Lordship is written, your lordship, in the iron structure, your lordship, Ashu Maya. Now, your lordship, kindly see page 39. We applied for the registration.
Yes, mark.
This is my mark. And your lordship, kindly see page 39. Page 39, your lordship, is, your lordship, my trademark application. And I was using the mark since, your lordship, 2nd of April 2016. Now, your lordship, I have given your lordship the invoices from page 41. That since 2016, your lordship, I am using your lordship Ashu Maya. And your lordship, the description of the goods, your lordship, the mark Ashu Maya, your lordship, is depicted. And from 2016, your lordship, I have given your lordship all the particular documents. Now, they have also, your lordship, applied for your lordship the registration. If your lordship kindly take page 75. Same mark, page 75. Lordship kindly sees the date of application, 4th of December 2023. And your lordship, the user detail is proposed to be used. And your lordship kindly sees same Ashu Maya, identical mark. And your lordship, they have, when they applied for the registration, they have disclosed certain invoices that they are selling within the jurisdiction. That is at page 78.
Yes.
Page 78, your lordship kindly sees Calcutta Filters Manufacturing Company. They are selling at 62 by 1A NS Road, Kolkata. And your lordship, this Calcutta Filters Manufacturing Company, I have also implemented this company, your lordship, as a party. So one of the defendant, your lordship, is within jurisdiction. They are selling the products within the jurisdiction of this honorable court, and their product, your lordship, kindly take page 93. Same hand pump, and your lordship, mark, your lordship, Ashu Maya, same. The way, your lordship, the writing and everything, an identical mark. And your lordship, the sale, their selling, your lordship, is within and outside both. Page 78, your lordship, I have shown. Then page 79 also, your lordship, the different invoice they have given. 80, your lordship, the same one.
Yes.
And 80 till, your lordship, 82, 81, your lordship, is within. 82, your lordship, Bajrang Trading Company is outside. So selling, your lordship, within and outside both.
When the cause of action arose?
Lordship, I have pleaded, your lordship, from July, your lordship, I have came to know. And then after, your lordship, I have given the cease and desist notice also. Paragraph 17, your lordship, I have pleaded from July 2024. When we made a search, your lordship, in the official website, we came to know that this particular application they have filed, para 17. And thereafter, when we make an inquiry, we found, your lordship, they filed another application from in which, your lordship, we have already filed an opposition. Para 17 and 18.
Yeah.
And your lordship, the cease and desist notice which we have given, that is, your lordship, at page 94, 17th August 2024, page 94.
What is the reply?
No reply.
No reply.
They have not given, your lordship, reply. Or rather, they have refused to accept it, your lordship. Page 98, your lordship, is your lordship, the track report we have given.
What is the prayer?
My prayer, your lordship, is because Ashu Maya, your lordship, is not the registered one. Mine and them both. So, your lordship, the prayer is restricted to, your lordship, passing off. Page 20 onwards. An urgency I have pleaded, your lordship. I'm grateful.
Only passing off.
Only passing off, your lordship, because both are not registered.
You have taken already. You have taken the application before the authority.
Yes, sir.
You have made the objection before the authority.
No, not, your lordship. Not objection, your lordship. It has not yet advertised. There is a departmental objection there.
Suffering for the plaintiff. The plaintiff has filed the present suit, praying for decree for perpetual injunction against the defendants and allied players. The plaintiff has prayed for leave under clause 12 of the letters patent on the ground that part cause of action arose within this court, within the jurisdiction of this court, and part cause of action arose outside the jurisdiction of this court. The plaintiff has also prayed for leave under clause under order 2 rule 2 of the Code of Civil Procedure on the ground that the plaintiffs came to know about the alleged mark used by the defendant, and immediately the defendant has issued the desist notice. Plaintiff has issued the desist notice, but in spite of the desist notice, the defendant has desist notice, but the defendant refused to accept the same. Alternative, the plaintiff has filed the suit, and there is every chance that further cause of action may arise with regard to the compensation and other claims. The counsel for the plaintiff also prayed for leave under section 12 capital A of the Commercial Court Act 2015 on the ground that in the month of July 2024, the plaintiffs came to know about the alleged mark used by the defendant of the identical product, and the plaintiff had issued the notice, but the defendant refused to accept the same, and there is an urgency to move the said application for grant of interim order. And if the plaintiff will initiate the mediation process, the right of the plaintiff will be defeated. Consider the submission made by the counsel for the plaintiff peruse the application and the pleadings. This court find that sufficient cause has been shown for non-initiation of the pre-mediation process, and there is an urgency to move the said application before initiation of the pre-institution mediation process. Considering the above, leave under clause 12 of the letter patent of 1865, order to rule 2 of this Code of Civil Procedure, and leave under section 12 capital A of the Commercial Court Act is granted. Plaintiff is admitted subject to scrutiny by the department. Next.
I'm grateful, Your Lordship.
Milord,
Adi Mohini Mohan Kanjilal, yes.
100-year-old shop, Milord. Adi Mohini Mohan Kanjilal, Milord, was a Milord businessman who came down to in Calcutta, Milord. He was from East Pakistan. Now, Milord, he formed a shop in College Street, Milord, under the name of Mohini Mohan Kanjilal. Lord, you must have nowadays, Milord, gone to Mr. Obhrojit Mitro's house, Milord, just beside that, in Milord, Mohajati Shodon, just behind that. Now, Milord, his Milord ancestral house. So it's in the corner of College Street, Milord. There is a split in the family business, Milord. Milord, they come down, Milord, to some sort of settlement, they divide. Two Mohini Mohan Milord branches, Milord, from their forefathers divide. So it's the name of their predecessors in interest, Milord. Milord, they divide. Milord, this branch, the plaintiff writes, Milord, Adi Mohini Mohan Kanjilal, Milord. Adi Mohini Mohan Kanjilal, I'll prefixed with Adi. Adi means the older, or the old one. He will use, Milord, Mohini Mohan Kanjilal, Milord. Simplicity. So that was the understanding. There was a breach by Milord, the other branch. I came to court, you cannot use Adi. Justice Sengupta, Milord, says, yes, you can't do that. Because that's my registered trademark. Milord, this is a very reputed shop, Milord. So far as now it's being run by the one of Milord, the Milord daughter-in-laws, Milord. Now, Milord, Shonchita Kanjilal, Milord. Now, Milord, the defendant, Milord, is also my Milord. I have a registered word mark. If your Lordship kindly takes, Milord, my registered word mark first, Milord. It's an infringement action 29.5 as well as 29.1. Kindly, Milord, have, Milord, page 97 once. Status to know. Has Lordship found out page 97? Yes. of the petition. This is legal certificate, Millard. Millard, Adi Mohini Mohan Kanjilal Marketing Private Limited. It's not only my trading name or business name, but also my Millard trademark. Proprietor's address 79 to Mahatma Gandhi Road, Millard, Kolkata 9. Millard, registration date, Lordship will find just after details. Millard, 27th of August 2003. Millard, it has been renewed and valid till 27/8/2023. It has been again, Millard, renewed thereafter. Renewal term. That Lordship will find, Millard, from the status report. No?
August 2023.
Yes.
It is over.
Yes. No, I'll hand up, Millard. I'll hand it up. Yes. Kindly, Millard, takes Millard. The legal certificate takes time, Millard. So I am giving the status report, Millard. It is continuing, Millard. Its registered status is registered. Lordship can see that is valid up to 27/8/033.
Not 23. Yes.
So I told them, Millard, to bring this because in respect of saris, it's a word mark. Lordship sees it's a word mark.
Yeah.
Now, Lordship will now straight away come to my next registration. This is only in respect of saris. Now, Lordship will now kindly take, Millard, page 101. O status report.
101.
101. This is in respect of clothing, ready-made garments of all kinds, footwear and headgear in class 25. That was 24. This is 25. Millard, I am doing this in 2005, Millard, because I was mainly in saris, Millard.
It is the clothing.
Clothing and clothings.
Body
Similar goods, Millard. I have sari, I have clothings. This is also, Millard, name Adi Mohini Mohan Kanjilal Marketing Private Limited. The mark in question is Adi Mohini Mohan Kanjilal Marketing Private Limited. This is the trademark which I have got it registered. Now it's word mark, user since 1/4/2005. Goods description, clothing including ready-made garments of all kinds and headgear. Lordship will kindly take the status report also, Millard. This is also continuing. This is registered in my name. Trademark applied for is Adi Mohini Mohan Kanjilal. Oh.
Yes.
Lordship has already, Millard, held in one of the cases. Despite having your registration, you have to give your user details. So, Millard, I have given that. First of my invoice, if your Lordship kindly have a look, is, Millard, which I showed to your Lordship. The first invoice, or a Lordship can take the advertisement. It's page 57, Millard, if your Lordship takes. It's, Millard, the oldest I show, Millard. 16th of November 1998, when, Millard, my name of my shop appears. This is in Bortoman, one of the oldest, Millard, or, Millard, well-known newspapers in Bengal. The date is 16 November 1998. The type copy is on the next page.
Yes.
And Lordship must have heard the name of Anandabajar Potrika here, Millard. Has the largest circulation. Page 60. 8 July 2020, 8 July 2000, Adi Mohini Mohan Kanjilal.
Yes.
So Anandabajar is also there for Lordship's satisfaction or conscience, Millard. The invoices are annexed, Millard, but those are, Millard, since they are very old, Millard, not very legible, Millard. The first I can give, Millard, Lordship will take the type copy at page 33, capital A, Millard. It's 2009. 33, capital A, 2009. Now what is it?
33.
Capital A, Millard. The type copy, Millard. I have the originals. It's not coming out in Xerox, Millard. Since, Millard, printed bills, Millard, it's not coming out.
2009.
Yes, Millard, it's not. It's the next page, Lordship will find. It's I given the type copy. I have the original at the time of suit, Millard. I'll do. Now, Millard, the defendant is very clever. Millard. Kindly have a look at page 102. Very recent Millard one, Millard I got it purchased, 102 Annex G.
Yes.
Adi Mohini Mohan. Kanjilal is a surname, Millard. Adi Mohini Mohan. That's Millard, page 102 of your lordship's brief.
Yes.
Singur Bajar, near police station Singur. Mobile number is very important because I'll show Millard. And Millard, GST they are not giving. Millard, this is amount is 495. Now, Millard, when I make payment by GPay, lordship will kindly take Millard, page 103. Because the moment you pay in Millard UPI, it's run by someone called Calcutta Furniture, page 495. Amount matches Millard, and it's so Millard I could get the name of the defendant because this is payment by GPay.
Yes.
Then who is Calcutta Furniture? Page 104. This is the GST is Millard. They are not taking GST. 104. Prashanto Ghosh, trading name Calcutta Furniture. He is registered under the GST Act, Millard, 24th of August 2017. It's a proprietorship concern. And Millard, they deal in page 106, polishes, screens, plywood, furnitures, etc., etc. Otherwise, Millard, I could not have traced the defendant. There's a transaction recorded, to Messrs. Calcutta Furniture. Because
When
lordship,
is doing this business?
yes,
Since when he is
recent
doing
shop. Millard, I am 100 years old, Millard.
No.
At least from 9 recent shop. Now, Millard, kindly take Millard.
How in the furniture shop the clothing has been selling?
Millard, he's Millard not registered himself, Millard, or not got a GST registration of clothing because it's below, must be below 20 lakhs. So by moment I make the payment, Millard, it's Millard enrouted Millard to Calcutta Furniture. Millard, kindly look at the timing, 18th, 102, 18th of September 2024. Millard, bill is Millard at Millard 19:07:49 hours. And Millard takes 18 September 2024. Payment is just made prior to at page 103 at 7:05 p.m. And he is Prashanto Ghosh. Kindly take Millard, page 104. Trading name Calcutta Furniture. Effective date 24th of August 2017. Constitution of business is proprietorship. And then lordship takes 106. Sari is not there. So this is fraud, Millard.
Yes.
Now, most important, Millard, to make my lord's conscience, Millard, because I nowadays see it, Millard. 102, Millard, kindly now, Millard, lordship will find a telephone number 7439 111 258 at 102. That, Millard, on a caller tune, Millard, 109, it's Adi Mohini Mohan Shingu. At a true caller, Millard, 109.
So they got the phone number in this number?
In this link. But Millard, Millard, one has to sue Millard, a person, either a natural person, or Millard, a legal person, or Millard, someone requires Millard, a juristic person. Millard, I cannot go Millard, write Mohini Mohan. Yes, it can be done Millard in trademark cases. Lordship knows Ashok Kumar or Millard, Anton Millard, whatever they call it Millard. John Doe, Anton Millard told. But that's very difficult to enforce an order. Page 110 is the Millard shop. Adi Mohini Mohan. 110 Millard, their shop.
Yes. Is a defendant shop?
It's a defendant shop. Plaintiff shop is
Yes.
Now, Millard, this is how they sell their product. Judge Shepidin. These have crave leaf. I am Millard and S. And this is their sari, Adi Mohini Mohan, Monoranjan. Let them write Monoranjan or Adi Monoranjan. Why Millard Mohini Mohan, Adi Mohini Mohan? Monoranjan Lordship will not file in the bill. It will Lordship or in the Miller hoarding. Lordship will find it in the sari. This is a case of deceit. Lordship, kindly now, Miller, have a look at the Trademarks Act first. বিলটা দাও না যেটা অন্য আরেকটা যেটা প্রথম কিনেছিল 495 ছাড়া কপি থাকলে দাও জিপেটা কোথায় ওগুলো yes now lordship will kindly take section 29 subsection 5 Miller.
Yes.
This lordship will not find Miller in the trading name concept because this is a stricter. A registered trademark is infringed by a person if he uses such registered trademark. If he uses such registered trademark as his trading name, it doesn't help, not the full one, or part of his trading name, or name of the business concern, or part of the name, or his business concern, dealing in goods or services in respect of which the trademark is registered. Normally, I come, Millard, in trademark action, Millard, and say, Millard, look, you have a registration, say, Kit Kat yellow. You don't have Kit Kat per se, or Duro Touch. You don't have Duro per se. So, per se, it's not an infringement of Millard Duro. Now, Millard, by Millard, the Millard Lordship's judgments, Millard, or the court's judgment, now Millard, part of registered use of a registered trademark is also an infringement of trading name as well as trademark. But the section 29, Millard, it's in the act itself, Millard, trading name or part of the trading name. Millard, I squarely fall within that, Millard. So I'll be pressing for an injunction in terms of prayer A of the petition. It's injunction of my trademark, injunction of my trading name. Millard, he is Calcutta Furniture. Let him do Adi Calcutta Furniture, Millard, or Adi Monoranjan. Why Adi? In fact, Millard, Adi Millard, Lordship will find Millard has been protected by this court. Judgment is not. Lordship will kindly consider Millard prayer A, Millard. Now, Justice Sengupta judgment. If your Lordship considers prayer A, there are two corrections should be made, Millard. It should include the trade name also. If so commences. Otherwise, Lordship can pass A and B, Millard. Lordship will find Millard 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12th line, Millard, after impugned, Millard, trademark, the word trademark would be written or trading and or trade name. And in the second last line of the paragraph, third last line, trademark and or trading name.
That is there.
Yes, no. Trade name is there, trademark is missing. Otherwise, Lordship has to unnecessary pass again.
Or any other trademark.
Impugned trademark and or trade name and or style Aditi Mohan or decept plaintiffs, trademark and or trading name. If Lordship permits, Millard, correction, and this is the judgment I was talking, Millard. This is Justice Sengupta. In between family also, he said, Millard, you should not use the word Adi, Millard. This was a on contest. Millard, para 19, if your Lordship takes, Millard, 19 and 20. And Millard, 22. I'm not placing it because we are before the Millard vacation, Millard. And delay also was considered, Millard. Delay is not a ground. Lordship will take from 19 onwards to Millard 23.
Yes.
Prayer A, Lordship. Lordship permits me, Millard, to correct the prayer, Millard, in the manner. Grateful.
So applying for the plaintiff. Plaintiff has filed the present application for identity injunction. Plaintiff says that
for Lordship's convenience, I just hand. I'm sorry, well, I should have given it as a similar order by the coordinate bench if some help is for it. This was Millard Adi Mohini Mohan NX or Millard Adi Mohini NX.
Plaintiff says that the predecessor in business has all no, it is At all material times, the plaintiffs carrying on business of manufacturing and marketing sarees under the trademark are manufacturing and marketing sarees under the trademark Adi Mohini Mohan Kanjilat inward comma caps, which also forms the key part of its corporate name. Petition the plaintiff is also selling the goods through the franchises over Eastern India. Originally, one Srimati Sanchita Kanjila, the predecessor of the plaintiff, in order to distinguish the said goods from those of others in the trade, on or about 1998, had adopted the trademark Adi Mohini Kanji in a bona fide manner in respect of saris when no one else was using the same in respect of the such goods. And since then, she had been openly, continuously and extensively using the said trademark in the course of trade. The term Adi is which is prefixed to the trademark Mohini Mohan Kanjila, used to suggest that the general public and the members of the trade with the petitioner's showroom and members of the trade full stop. In the year 2005, the proprietorship business of Srimati Sanchita Kanjilar was converted to a partnership firm. In the year 2023-2024, the turnover of the business of the plaintiff is rupees 1, 28, 48, 81, 452.47, and the plaintiff has also made expenditure for the advertisement of the said business, and in the year 2023-24, the plaintiff has made expenditure of rupees 8, 04, 41, 328.67. Yes. The plaintiff is the prior adopter of the said mark, Adi Mohini Mohan Kanjila, and has acquired exclusive right to use the said mark for the said goods under the common law, and no one else who is not common law, and no one else who is not connected with or authorized by the plaintiff has a right to use the mark Adi Mohini Mohan Kanji or any other mark which is identical and deceptively similar to the petitioner's, to the plaintiff's mark. Number next. In order to obtain statutory protection of such exclusive right to the use of Adi Mohini Mohan Kanjila, on 27th of August 2023, the plaintiff company has applied for registration, being application number 1227447 under class 24 under the Trade and Merchandise Marks Act, 1958. In the month of December 2010, the plaintiff filed another application, the class 25 of Trademark Act 1999 before the Trademark Registry for registration of mark Adi Mohini Mohan Kanjilal in respect of ready-made garments, which was also registered. The counsel for the plaintiff submits that in the first week of September 2024, the petitioner came to learn that the defendant has started using the mark Adi Mohini Mohan being deceptively similar and containing the essential part and prominent feature of the plaintiff's registered mark Adi Mohini Mohan Kanji. Immediately the petitioner has purchased a representative of the plaintiff purchased a sari from the defendant on 18th of September 2024, where from its showroom/shop of the business at Singur Bazaar, which evident that the defendant has clearly and prominently written the impugned mark Adi Mohini Mohan, the counsel for the plaintiff submit that the mobile number mentioned in the tax invoice dated 18 September 2024 is also the part of the defendants, as evident from the screenshot of the Truecaller while making the payment to UPI. The name of Mrs. Calcutta Furnitures appear in the screen. Counsel for the plaintiff submitted on further inquiry. It was found that one Prashanta Ghosh was carrying the business under the name and style of Calcutta Furniture and obtained registration under the trade name Calcutta Furniture. But subsequently, dishonest intention to earn goodwill and reputation of the plaintiff's registered trademark and also the key part of the trademark name, the defendant had adopted the impugned mark and using the same as trade name only to cause confusion and deception in the minds of the general customers. Counsel for the plaintiff submits that apart from the writing in the impugned Adi Mohan on the invoices, the defendant is also using the same trading style of the trade name written in the signboard displayed at the top of the entrance of the showroom of the defendant. The plaintiff further submits that on perusal of the bag and packets of the respondent, which are sold and marketed and distributed, as well as for the signage and banners used by the defendant, the mark Adi Mohan is written and embossed on the same and identical manner, both in English and in Bengali. Counsel for the plaintiff submit that the defendant has adopted the impugned mark containing Adi Mohan as its trademark and trading style in respect of identical product, sari, and the similar business as that of the plaintiff. He submits that the plaintiff at the time of adoption of the impugned mark, the defendant being the same business was fully aware that the plaintiff mark Adi Mohan, which has been acquired tremendous popularity among the customers. Counsel for the plaintiff submits that the plaintiff is using the trademark of the plaintiff's business descriptively similar to the mark of the plaintiff and the product and the similar product of the press for identity injunction. At the learned counsel for the plaintiff or use the materials on record. It is fine from the record that the plaintiff has obtained registration mark on 27th of August 2003, which is valid till 20th August till 2023. Initially, the plaintiff has obtained the word mark of clothing for saris. Subsequently, the plaintiff has also obtained trademark of the clothing on 28th of 2010, which is valid up till 28/12/2013. The plaintiff has purchased the sari from the shop of the defendant, wherein the tax invoice of the defendant shows Adi Mohini Mohan. This one, Adi Mohini Mohan. And the plaintiff has paid an amount of rupees 495 through the UPI. In the UPI, in the true caller, it is shown that the name of the defendant shop as Mrs. Calcutta Furniture. The plaintiff has also obtained the goods and sales tax document, which shows that the trade name of the defendant is registered as Calcutta Furniture, and the business of the defendant is the description of the business of the defendant is polishing and creams for footwear, furniture, floors, catchwork, glass or metal, page 106, metal, scoring, pastes and powders and similar preparation. Counsel for the plaintiff submitted. From this document also it shows that the defendant is not having the business of clothing or saris, but only to get the benefit from the name of the defendant's business, has started the business of selling the sari and putti under the same name and style of the plaintiff. The plaintiff has also relied upon the invoices, which shows that the defendant is selling the sari under the name and style of Adi Mohini Mohan Kanjilal since 1998. The counsel for the plaintiff has also relied upon the judgment reported in the case of Sanchita Kanjilal versus Mohini Mohan Kanjilal and others, reported in 2003 SCC Online Calcutta 324, wherein the coordinate bench of this court has categorically held that the plaintiff has been able to establish that C is the first user of the word Adi ADI and has been using the same. This court has further held that the respondent did not even think of using the word Adi when they applied for registration of the trademark Mohini Mohan Kanjilal and Sons. Not the learned counsel for the plaintiff or use the materials of the court. बोल दिए तो considering the above, this court find that the defendant is not having the trademark of Adi Mohini Mohan and the defendant is having the trademark of Calcutta furniture, having the business of furniture, but the defendant is selling the saris and other clothing under the name and style of Adi Mohini, which is deceptively similar to the mark of the plaintiff. This court also find that the plaintiff is the exclusive owner of the trademark Adi Mohini Kanjilal by virtue of distinguishness and bona fide and prior adoption of extensive user, and no one other than the plaintiff are entitled to use the trademark, which is identical and deceptively similar to the British plaintiff's trademark. Considering the above, this court finds that the plaintiff has made out of FSI case and balance of convenience and inconvenience favor of the plaintiff. This could also find that if anti-stage and identity model is not found, the plaintiff will suffer irreparable loss and injury. In view of the above, the defendant, his man, servant, agent, representative, and each of them or any other person acting on behalf of the defendant is restrained from infringing the plaintiff's registered trademark Adi Mohini, trademark or trade name. Trademark and trade name Adi Mohini Kanjilal by manufacturing, selling, marketing, distributing, advertising, or otherwise dealing in sari or any other allied goods under the impugned trademark and trade name and style Adi Mohini Kanjilal or any other mark or trade name or trademark which is either identical with or deceptively similar to the plaintiff's registered trademark Adi Mohini Kanjilal till 19th of November 2024. The plaintiff is directed to immediately serve the copy of the application, documents, and the copy of the print to the defendant, and to file affidavit of service on the written affidavit. Let the matter appear on 19th of November 2024.
Order in terms of prayer, Lordship is granted. Miller only permits me to correct Miller prayer in the manner Miller I think.
The plaintiff is granted liberty and leave to add the word trademark, trade name.
Trademark just before the word trade name. Trademark and or trade name.
Word trademark.
Miller, it will be
2, 3, 4, 5,
6, 7, 8, 9, 10.
Trade name. क्या बोला? What trade name in the fifth line of prayer A after the word trademark and
দশ জন fifth হবে না তো? Miller, may I just hand up?
11th line after the word and the word trademark after the word trade name. After the word which your trade name in and
or trademark. I'll do it in the 11th. It may be the line I'll count and indicate to Lordship. Grateful.
And to make the initial after the correct.
Grateful. Much obliged.
Yes, next.
Miller, this is my application.
Yeah.
This is I am enjoying an
The way my lord is giving his dictation so fast reminds us of Justice S.B. Sinha. And let's leave that stenographers find it difficult to record so fast. My Justice Sinha was dictating. Anyway, my lord, this matter, my learned friend has finished his argument as he said last occasion.
Which one?
Judgment. Next
No,
time.
I
You have
next
said that
man-
you have finished
No,
your.
I have shown judgments. You did not hear me properly.
No,
Which
you
one?
said
Evidence?
that.
I have finished my argument
Plywood.
on facts.
Plywood.
Yes, yes, right.
Okay, just pass the
Malan,
one
Malan.
supplementary list I will call then.
Facts আমার বলা হয়ে গেছে বলেছি।
नहीं रख दो सेम रन रखो।
My lord, I had handed up, my lord, a
Yes.
copy of the order. Now, my lord, only at page 15, my lord, if your lordship kindly turns.
Yes.
My lord, after, my lord, the special officers. My lord, I was suggesting, my lord, kindly take, my lord, the 2 pages I've handed up, my lord, at page, my lord.
Yes, I got it.
Yes, my lord, the last 2, my lord, paragraphs, my lord, were the only ones which were actually covered, my lord, by the prayers. And the last page, last 2 lines are covered by a prayer, my lord. The rest, my lord, is for effective. My lord, I can give you a lordship, my lord. Breaking open locks is prayer F, page 66. Lordship will find that. And my lord, other premises also, my lord, is prayer F, page 65. And my lord, the last 3 lines are, my lord, prayer I at page 68.
Print আছে কি? Print नहीं है?
My lord, the petition I have, my lord, I can have a copy of the petition. Are you are coming here for corrections and you don't have a copy of the petition. My lord, may I hand up, my lord? My lord, your lordship's right, my lord. Many things are not there in the press, but my lord, prayer F, my lord, your lordship kindly takes page 65. My lord, 5th line from the top, my lord, at the addresses aforementioned or any other premises. So, my lord, that is, my lord, the last 2 lines, my lord, of, my lord, the first page of the corrections. And, my lord, thereafter, your lordships will find, my lord, the next page, page 66. My lord, there is, my lord, for, my lord, breaking open.
Yes.
My lord, middle of the page, my lord, for breaking open locks, shutters of the premises, my lord, is also there.
Yes, got it.
And my lord, similarly, my lord, at page 68, my lord, prayer I, my lord, your lordship will find. My lord, I have not mentioned the number of certified, but I've said sufficient certified. My lord, copies here, my lord, because your lordships appointed, my lord, 6, my lord, 7, we've asked for, my lord, 12. And my lord, as far as inventory is concerned, my lord, that is also, my lord, mentioned. My lord, in prayer, my lord, your lordship will find. Oh, sorry, seizure. Sorry, seizure is mentioned. At prayer F, my lord, also.
Take possession of any article.
My lord, search and seizure, your lordship will find just after locks.
Yes.
My lord, and we had not mentioned inventory. My lord, which I think, my lord, to protect the special officers, your lordship kindly directs, my lord, that they're also having it.
मैंने तो ऑर्डर कॉपी इशू हो गया था ना ऑर्डर कॉपी इशू कर दिया था ना counsel for the matrix listed as to be in the supplementary list the matrix listed as in the supplementary list on the prayer made by the counsel for the printing. This could by an order dated 27th of September 2024 had passed at interim order. But today, learned counsel for the plaintiff has mentioned that inadvertently some of the prayer has not been incorporated in the said order, though the counsel for the plaintiff has make appropriate submission. Full stop. Counsel for the plaintiff submit that. Full stop. Considering the submission made by the counsel for the plaintiff, this court find that after in page 15,
Next matter, all
after
things are added.
after the paragraph 5, the following is to be added.
That should not in this matter.
This one. Again,
The phone could have taken off.
this could also find that in paragraph page 16, last paragraph of the order dated 27th of September 2021, 2024, it is to be added. The same is to be added. For the purpose of carrying out commission, the plaintiff be provided 12 certified copies of the in color. Order in color. Order in color you will get.
Where your lordship?
Manudosh, color order you will get. Yes.
My lord, I have a copy, my lord. If your lordship wants, my lord, I can give.
No. Color certified copy.
Oh.
That is the problem. Or because the
I know.
assistant registrar only one, he can certified only one copy.
I see.
So and that will be given, but there are for the purpose of carrying out the commission provided 6 copies is enough, no? 6.
My lord, I think 7, my lord, would be Fortune special officer.
6 persons have been appointed.
7 have been appointed.
7, my lord. 7.
7 appointed for 6 locations.
For 6, okay.
One is 2.
Yes, 1 is 2.
One here, one
Yes.
place 2 persons have been appointed because there are 3 locations.
Right.
For the purpose of carrying on commission, the plaintiff be provided 12 instead of 12, 7 certified. 12 certified copy methods, 12 plain copy of the order. The order duly attested by the
Obliged,
assistant
your
registrar. Duly.
I'm grateful.
Duly certified by the assistant registrar. ठीक है, कोई तो ये ऐड हो जाएगा, यहाँ में ऐड होगा, फर्स्ट ऑफ यहाँ ऐड होगा, सेकंड ऑफ डिक्टेशन दिया ना, ये नहीं हो रहा. फॉर द पर्पस ऑफ कैरिंग आउट द कमीशन, फॉर द पर्पस ऑफ, ठीक है, कर दो commission, the plaintiff and the plaintiff be provided 7 certified 7 attested copy of the order duly certified by the assistant registrar.
I'm grateful. Mr. Bachawat's presence should also be recorded.
I will be invited by the
Yes, next.
My application, Miller, the injunction, Miller, that my learned friend has a vacating application, plywood, metro, and both are metro. My learned friends will say it's not metro, it's metro, Miller. Now, Miller, I stopped, Miller. Factually, Miller, last day I said, Miller, more or less completed. I'll now show judgments, Miller. Miller, prior to that, if your lordship kindly takes the vacating
urgency.
Yes, my lord, I am suffering, my lord. My lord, on the face of it, I can show my different contention is absolutely misconceived. He has his description in the plaint itself in the application in describing my trademark, my mark.
What is the
which
ply?
is impure.
It is a ply.
It's a plywood. My friend said it's a capital MEMCTRO. It's not capital. It is followed by 710 number. On the face of it, not it's
phonetically similar, Miller.
Politically, how can
phonetically
MC
similar?
and MT is similar?
If Renessa and Psi Renessa are
Yes, yes,
similar,
that-
it's HON'BLE and HON'BLE are similar.
absolutely,
This is
but I
also
have
similar.
authorities.
Yes, I'll show authorities.
Section
Don't worry.
17 absolutely.
Yes,
but
I'll show. Don't
he has
worry.
not corrected his plaint itself.
Yes, I don't need to. I have a word mark. That's the end of the matter. Yes, let us see. Willard, kindly take his vacating application.
That he has completed
No,
sufficient-
it's there in the there is in the YouTube. Lordship will say what I have said.
Any confusion?
Yes, yes.
Any
You make
confusion?
your argument when I finish.
Yes, I'll do.
Yes, definitely do.
वो दोनों जन-
These
this
threats
order
are
is
uncalled for.
incorporated to say order.
I have said I finished on facts.
Yes,
Yes, yes.
एक हो गए.
Why are you so agitated? Of course. Kindly Miller takes the vacating application.
Yes.
Millard, kindly take Millard para 5, para 3 of his vacating application, because he has a vacating application.
Vacating
His
of
Millard
it,
GA
have you-
number 3 of 2024.
Have you filed the affidavit?
I have filed affidavits are complete.
Paragraph 3.
Paragraph 3. Millard Metro, and he says he's MCTRO 710, all caps. That's how he's writing. This is his petition. Now, Millard, kindly take Millard.
It's not my writing. Kindly, I request my letter to read the entire sentence.
I don't know whether this interjection will when stop.
No. He's misleading.
Okay, you will get time. You will get time. See, I am not going to pass the order on his submission.
This is my writing.
What
It's
he is
not my-
telling, I am taking note of it. What you will submit, then the court will make the
Absolutely,
opinion.
I bow down. Absolutely.
Yes.
This has now become Millard, two parties Millard speaking at the same time. Kindly Millard say Millard, para 4. The applicant states that on close reading and examination of the letters used and the style in the manner used in the trademark applicant, that the respondent number 1, it will transpire that both our marks are not identical, deceptively similar, and by no stretch of imagination the two trademarks can be branded similar as or identical, deceptively similar. Therefore, use of the mark M, it says, is according to me it's Metro 710 cannot be any violation of the provision of the Act. Now, Millard Lordship will take para 6. It's according to me, it's common to trade. Now, Millard, kindly take para 7. Para 7, Millard. If your Lordship takes Millard 10 lines from the top, Millard, the applicant or Millard takes the entire paragraph. The applicant states that the word Metro has been used as a trademark of different companies of different products. Even for selling plywoods, apart from the plaintiff, another name, Ashok Sharma, has been using Metro Gold. Similarly, another entity, Unique Gold, has been using the mark Metro Mica for manufacturing of plywood. And Millard, plywood, likewise, other person, Proshanta Ramurtia, Petro Club, and another company known as Punia Plywood using the label Metro City. So, individual Metro, Millard, I have only got registration. Therefore, it is crystal clear that the plaintiff cannot claim exclusivity of the mark Metro by applying anti-dissection rule. Millard, this doesn't apply in respect of a word mark.
Where from you are reading?
Millard, para 7 of Millard, the vacating. Millard, a trademark can be label, device, or a word. Now, this anti-dissection theory is a concept, Millard, of section 17. Now, Millard, section 17 doesn't have any application, Millard, with deepest of respect in a word mark situation. Now, Millard, I have a word mark registration. So, if I have a word, I have a word. Where is the question of Millard anti-dissection, dissecting it, Millard? If I have a label, it has many features, like Millard Kit Kat label, red label, word Kit Kat, heart, etc., etc. This is his case. Now, Millard, therefore, it is clear from paragraph 7. Therefore, it is clear, 8 lines from the top, the plaintiff cannot claim exclusivity in respect of the mark Metro, even applying anti-dissection rule, if a close comparison is made between the matter, style, phonetic, or sound. Metro and Metro 70, even dissection of the phrase of the plaintiff deceptively similarity must fail. That's his case. Now, the plaintiff states that not only the word Metro as a whole is distinct from Metro, but the word number makes the mark of the defendant distinct one. Defendant has got BIS registration and uses 710 as part of his mark. My learned friend, do not have Millard, any Millard registration. Now, Millard, he says, Millard, paragraph 11, page 11, that Millard, if Millard, I have not opposed his mark, so I am not entitled to injunction. His mark is not registered today. It's opposed by someone else. So, Millard, until he is registered, it's an infringement action. Even if it's registered, Millard, even Millard, there is a registration, Millard. This argument is without basis, Millard, because even it is without registered, Millard, then Millard, one has to fall back on 28.3 Millard, who is the prior use, starting from the Whirlpool's case. Now, Millard, kindly take Millard his documents one by one. Kindly, Millard, takes page 23. That's his license, Millard, BSI license, Millard, which is 16th of April 2024. It has already expired according to the document in question. Kindly take page 2023. It's a BIS or ISI license according to the document given to the court 17/4/2023 to 16/4/2024. So, Millard, the validity is not there. I do not know, Millard, whether there is anything on there because I am taking his vacating application as true and correct. So, Millard, this IS
where
or
is
the
the date?
DS license.
16th April.
Yes, kindly take, Millard, 17 for 2023 to 16 for 2024. So, Millard, his so-called Millard 710 IS, Millard, he has those registrations, so he is writing that has already expired to 16th of April 2024. It shows from the document there is no other documents on record. So it's an expired document. Now, Millard, kindly take, Millard, the next one, such report.
26.
26. Millard, he has given us such report. Details. I'll be, Millard, indicated, Millard. The first mark is my mark. Page 26. Metro Regency Plywood registered 1/1/1992 in respect of plywood. So the first mark is, Millard, my mark. Rest, Millard, are not in tiles, not in plywoods. They are in tiles or some other mark. Lordship can take, Millard, one by one. Metro lime is lime powder. The next one. Metro, Millard, is all kind tiles of all kinds. Metro Oplast. The, Millard, fourth entry is plaster of Paris. Metro lamp, the fifth one, is decorative laminates, etc., etc., building materials. Now, Lordship will now come, the next one, page 27. Metro Gold. That's, Millard, the third item. Metro Gold.
Yes.
The third item is Metro Gold. Application is 3/11/2008 and user is 1/6/2004. It's after me in respect of plywood. It's registered. I am the prior, 1992. Lordship, I have shown, Millard. So, Millard, now kindly now takes page 28, bottom. Metroply is my mark. Metroply, last one, I am Metroply. Now, page 29, second entry, Metro Mica Plywood under rectification. My mark is not under challenge. I am not even under rectification. Page 29.
Yes.
Then Metro Club, also plywood, rectification filed.
Metro Mica.
Metro Mica rectification flight. It's in respect of plywood. The user is 1/8/2017. I am, Millard, 1992. Rectification initiated.
Yes.
Now, Millard, Metro Club veneer door plywood rectification flight 1/7/2018 is the user. Now, Lordship will now blindly come after Metropolitan, that's marble garment. Also, it's called shuttering ply. Metroplex, it's opposed, so it's not registered. Then Metro City. So individual Metro, Lordship, is not having except the plaintiff herein. Rectification filed in respect of plywoods. Now, Lordship will now take the next page. Page 30. Metro Future. Plywood, it's objected, means at the show cause stage. Now, Metro Future Homes, it's Willard opposed. And Metro Laminates, the second last entry is also opposed. So, Millard, if your Lordship takes, Millard, the petition of his vacating application, Millard, individual Metro in respect of plywood is only the plaintiff, that's the first entry. Metro with something may be there, but plaintiff is only with Metro. Now, Millard, kindly, Millard, takes, Millard, his invoices from page 32. None, Millard, shows that, Millard, there is any user of the mark Metro in question. So, where is the, Millard, prima facie case or balance of convenience or irreparable injury for vacating an interim order? None, none. Metro name, Lordship, will not find, Millard. He has various registration, Millard. That doesn't say, Millard, anything about Metro. There is no whisper. Now, Millard, most interestingly, this is, Millard, quite serious, Millard. My learned friend, case in the petition, Millard. Or my lord, why my lord vacating? Because someone's business is stopped. Now my lord, kindly take page 46 onwards. It's not a case, my lord, if a person who comes to court, my lord, should come with clean hand. A person who tries to vacate an order should also come with clean hands. My learned friend has, my lord, as many as 6 registration. Why metro? Kindly take in respect of plywood, 46. Plywood, my lord, kindly take passion gold. Now, my lord, 48.
No, plywood.
Plywood, next page, fashion gold. So he has a trademark.
This is a plaintiff.
Yes, defendant. Somir Chaudhuri. Now, my lord, again, page 48. Nagging ply. Also plywood, page 48. This is 2015. The previous one was 2014, date of application. Then 49.
Nagging ply.
Yes. Then 49. 22nd of November 2016. Plywood laminates, page 49. It's Royal Club. Plywood. Then Miller 51. Again plywoods. It's Miller again 2015 application. Miller it's Chaudhuri Enterprise SS Gold, page 52. Then next page, page 53. This is Miller 5th of Miller May 2021. Elegant plywood. Then Miller 55. Plywood laminates, page 55. It's also 5th of November 2015. Date of Genius plywood.
So how many was since 63?
Yes.
Till page 63.
Yes, it goes on.
These are the defendants.
These are the defendants' registered mark. So why this hunk to do metro today? Executive gold, so on, Excel, so on, so forth. So whether how many marks he has already registered? Where is the case, Miller, of the injunction his business has been stopped? If someone has, Miller, host of registration in his pocket in respect of plywood, Miller, where is the case, Miller, on Miller affidavit, Miller, of vacating his injunction of this order in question? Why metro? Now, Miller 64. This is his Miller, so-called, he gives a write-up why he has taken this Miller mark. Mectron Technology Office, page 64.
Yes, I am there.
At Greenville, US company, are aesthetically chemical formulator in a core focus in polymer, etc., producing high performance products of various. Our marine ply manufacture high cloth formulation of chemical and high technology process. Our brand Mectro 71 is the reason is the American company Mectron Technology to inspire and create a brand Metco 710. So write Mectron. Why write Mectro? So he has taken it from an American name, according to him. Then write Mectron. Why write Mectro? Now, Millard, he gives Millard some Millard write-ups on Mectron technology, and Lordship will kindly take Millard. Next Millard are his Millard audit report from page 67, which also Millard do not Millard mention Millard the mark Metro in question.
So whether this is a patent? Metro 7?
This is not his, of the American company. This is write-up from Millard, some YouTube or some Millard internet. It's a screenshot. My junior says Millard, it's a screenshot. From Millard, like Millard, we press the, we get internet. This has nothing to do with the defendant. Defendant Millard is Millard whom? Somir Chaudhuri Enterprise, Somir Chaudhuri. Mectron Millard is a technology of US company. So he has copied from US company and he says Millard, this is the technology in plywood. It's a Millard technology used for the purpose of chemical process. And he says, this is how I got Metro. This is Millard, our marine ply manufacture a high formulation chemical and technological process. Our brand Mectron is the reason that the American company Mectron Technology, Mectron to yet creates an impression of our brand Metro Met 710. This is how Millard the matter proceeds. Now Millard, his application, he has annexed, Millard, I'll show this audit report are all prior to his application of metro. Now, Lordship takes my affidavit in opposition once to the vacating application.
When you have applied for?
Yes, I'm just Lordship will
There
then.
is the application?
Yes, kindly takes the petition once, Milord. It's
27/5/23.
27th of May 2023. Kindly Milord takes his application. Page as proposed to be used.
Page?
Milord kindly takes the defendant's application, Milord, of the petition, Milord. Kindly Milord take Milord page 62, annexure G. Milord, Lordship will find it's published in Trademark Journal. It's applied on 27th of May 2023.
Page 63?
Page 62, my lord, of the petition.
Of your petition?
Of my petition. This, according to him, Milord, is not metro but mectro. MCTRO. Annexure G, Milord, application, Milord, is Chaudhuri Enterprise, 7th of Milord, 27th of May 2023. Milord, as proposed to be used, Milord, Kolkata, in respect of plywood. So, Milord, as on date of this application, he, Milord, did not have any use. Now, Milord, kindly, if your Lordship, Milord, takes back to the vacating application, even it's his last audit report at page 129. If your Lordship takes Milord page 129, that's his last audit report. It's 31st of March 2023. 31st of March 2023. So it's prior, Milord. So, Milord, this document doesn't show user of metro.
Page 133.
129 of your Lordship's vacating application. That's the last audit report.
1st March 23.
Which is, Milord, that is the last document on record. For the year ended 31st March 2023, page 129. So this is prior to his date of application of registration. So it has nothing to do with metro. No stocks, no sales figures, no advertisement expense. No statement how much the goods are lying in the godown. So where is the case of vacating an interim order? Now, Milord, let us, Milord, Lordship, one just document I'll show. Kindly, Milord, takes my affidavit in opposition to the vacating application.
Yes.
Kindly have a look at page 20. That's my lord's initial order.
Yes.
I'm not listing the entirety. The order is quite detailed. Lordship will kindly take, Milord. Council, page 21. I moved it saying, Milord, they're writing MCTRO. Not that I, Milord, said, Milord, METRO, Metro they are moved. That's Lordship has recorded. Counsel for the petitioner submits that in the first week of March 2024, the petitioner came to know from reliable sources that spurious goods under the same description, plywood, is being sold in the market under deceptively similar mark MCTRO 710. So I said so and I got the order, Milord. Because I, Milord, on open court said, Milord, it's MCTRO. The counsel for the petitioner submits, applied for registration, according to Trademark Authority issued a show cause notice, and the status of the pending proceeding authority is opposed. So infringement, Milord. Mark may not be, Milord, identical, Milord. It should be deceptively similar or similar. Now, Milord, considering the submission for the counsel of the petition, peruse document. The plaintiff has enclosed a document to show that the defendants are selling the mark under the mark MCTRO. So, Milord, MC, not ME. which is deceptively similar to the plaintiff's mark found from record of the defendant who is a dealer but also selling the product of the defendant numbers 1, 2, 3. In view of the above, the court finds that the plaintiff has made out a prima facie case and balance of convenience and an injunction was passed. Now, Millard, I showed Millard the mark in question, that's Annexure G. What is the mark he has applied for? And Lordship will be surprised to learn that even Millard, the trademark registry considers Millard his mark and my mark to be Millard absolutely deceptively similar. That is also I have shown Millard part of Millard my vacating application or his affidavit in opposition shows Millard that even the trademark registry feels that the mark is deceptively similar. And a show cause notice was issued. But Millard, 120 days gone, I could not oppose it, Millard. Now, Millard, on the law on the subject, Lordship will kindly take the judgments one by one. I'll just indicate the paragraphs. Register. কোনটা থেকে শুরু করবে বলো 69 টু এসসিসি দাও আছে just give me 1 minute এর নাম হচ্ছে আর আর ছেত্রী আছে যেটা আছে পাঠালে থাকবে বার করে এভরি ম্যাচে তোমরা প্রবলেম করো Millard kindly takes Millard the judgment of the division bench kindly take Millard the judgment of Dhansri Tea versus Dhanjiri Plantation Limited Millard. The division bench of our court. Kindly Millard, I indicate the paragraph. This is Millard 2008 volume 3 CHN 158. আনেছে কিন্তু দেখো পাঠালেও তো আনে না না kindly Millard have Millard the case of Millard Dhunseri T Millard that's Millard because Dhunseri and Dhanjiri were the two marks in question. Lordship will straight away come এনেছিস kindly Millard para 10 Millard if your Lordship takes তোরা পাঠিয়েছিস সব করে After hearing the learned counsel for the parties and after going through the materials on record, we find that the appellant has a registered trademark Dhunseri for the purpose of selling tea and various other allied marks as it appears from the various documents annexed to the application for temporary injunction. It further appears that the appellant has complained of the respondents alleging violation of the aforesaid trademark and also for alleged passing off against the respondent threatening a legal action. The respondent, as it appears from the answer to the question, to the application of injunction, they admittedly they are using the mark Dhansiri. So Dhunsiri and Dhansiri, so Millard not identical. As claimed by the meaning of the word Dhunsiri is different from the word Dhansiri used by them. It is further alleged the name Dhansiri was well within his right, which was registered with the Register of Companies since 1997, which is phonetically and structurally different from the mark Dhunsiri of the appellant. There was no question of any confusion. Same as here, Millard. After hearing the learned counsel for the parties and after going through the materials on record, we find the scope of investigation in an action for infringement of a registered trademark varies lot from one for passing off. As pointed out by a bench consisting of 3 judges of the apex court in the case of Durgadat Sharma versus NP Laboratories, AIR 1965 Supreme Court 980. In the former type of cases, one established that the essential feature of the plaintiff has been copied by the defendant. The fact that the get-up packaging and other writing of the marks of the goods on the packaging which he offers the goods so sales of different products clearly indicate the trade origin from the registered proprietor. It is immaterial, whereas in case of passing off, the defendant may escape liability if he can show that the added matter is sufficient to distinguish the goods from that of the plaintiff. In the case before us, in an action is one for infringement of a registered trademark and passing off, keeping in view of the quoted principles laid down in the case of Durgadat Sharma, we are of the view that the plaintiff has definitely made out a strong prima facie case to an ad interim order of injunction based on averments made in the plaint and the application for injunction, including by various documents annexed to the application. Although it is contended by Mr. Ghosh, this is Mr. Dhruva Ghosh, not me, the learned advocate appearing on behalf of the respondent, that the spelling of the two names differs, like the present case. We are not at all impressed by the submission. At this stage, it will not be out of place to mention the observation of the Honorable Supreme Court in the case of Cadila Care Limited versus Cadila Pharmaceuticals, reported in 2001 PTC page 300, where a country like India, where there are not a single common language, large percentage of population are illiterate and a small fraction of know English. In dealing with the case of this nature, the court should not lose sight of the fact that the purchaser may have absolutely no knowledge of English or the language which the trademark is written, or to whom the words with slight different spelling are phonetically the same. Applying the aforesaid principle, the case on hand, we are of the view that the purchaser of the goods by the appellant may be misled by the word dhansiri, as is deceptively similar to the registered trademark of the plaintiff and likely to have confusion or deception in relation to the goods which is registered. Mr. Ghosh, in this connection, strong reliance on Unicorn versus Uniply, reported in AIR 2001 SC in support of the contention. Even on the basis of the averments in the application of temporary injunction, we should not pass the order of injunction at this stage. In the case of Unifal, Supreme Court was dealing where the combined claim of passing of infringement, there was no common field of activity between the two marks consisting of the parties. The goods of the trademark were sought to be used were identical. The question has fallen for the decision at this stage of disposal of the application as to why prior user, but the answer is not clear from the advertisement of respondent. Lordship will kindly take paragraph 18. We are therefore find that the plaintiff has made a strong prima facie case to go through a trial. Once a strong prima facie case has been made out, balance of convenience in this type of case in favor of granting the prayer of identity injunction. Otherwise, the plaintiff may suffer loss and injury. Sri Patel such and such, learned for happiest we did not consider the aforesaid matter, while well-sentimental pressures are required to be followed while considering grant of injunction. And Millard order was passed. So Millard Dhunseri and Dhanseri. Dhunseri is the name of a Millard river Millard flowing in Millard. And Millard, in respect of Millard, the plywood Millard, Lordship will find Millard, same division being says, in respect of century and centurion, Millard injunction Millard should follow Millard, with a refusal from an order of city civil court. The copy there. Honestly, বলছি তো তোর তো তুই তো বললি আছে আমি তো তোকে পাঠিয়েছি বার করে দে তো তোমার সফট কপি বার করে Miller, this is also the division bench. Just one paragraph I indicate. This is centurion. The word mark was registered. Dhunseri also Millard, word mark was registered. Now Millard, kindly Millard takes Millard. Copy দাও নি কপি দাও না আদার সাইডে কপি দাও তোমার থেকে বার করে দাও ওরা আনেনি বলছে এনেছে তারপরে Lordship will see the two marks century and centurion. IAN has been added. Now Millard, kindly Millard, have a look at where Millard the anti-dissection theory was also Millard argued. Millard, kindly have a look at paragraph 12. The plaintiff has obtained registered trademark Century, and there is no dispute that the plaintiff has been using the trademark from 1993. Here, Millard, I am from 1992. And has sold to the tune of 630 crores. Such fact has not been disputed by the defendant. The defendant has started selling products under the name of Centurion by using 6 syllables to the word century, consisting of 7, had been adopted in an addition of the 3 new letters IAN, have been added by the suffix. Phonetically, there is very small difference between pronunciation of the two marks. As this stage, it will be profitable to refer to the observation of the Supreme Court in the case of Cadila versus such and such, the what is quoted. Now, Millard, paragraph 13. So, Millard, I show it from here, Millard. So, Millard, I do not have to show the judgment. At this juncture, We may refer to the decision of the Supreme Court in the case of Corn Products versus Sangila, reported in AIR 60-142, where the apex court, while considering the question of deception regarding the words gluvita and glucovita, how dissimilar they are, observe that the question whether two marks are likely to give rise to confusion is a question of first impression. According to the said decision, it cannot be overlooked that if the words in an English word, which the mass Indian people is a foreign word, in deciding the question of similarity between the two marks and those to be considered as a whole and applying the principle to the appellant's mark, the two marks are identical. The syllable, in our opinion of the Supreme Court, not such would enable the buyers in our country to distinguish one mark from the other. The Supreme Court further observed that while deciding such question, the court should approach it from a view of a man of average intelligence and imperfect recollection. If glucovita is held to be deceptive to qualify gluvita, we do not find any reason why centurion should not be held to be deceptively similar to century. Applying the aforesaid principles and laying down the test of Supreme Court, we are of the opinion that the additional syllable IAN of the suffix added by the respondent by deleting the syllable Y of the Y's amounts to adoption of an essential feature of a trademark of the plaintiff. Thus, a strong prima facie case has been made up to considering both parties for dealing with the materials plywood the plaintiff sold under such a. Once it is established, strong prima facie case has been made out, the balance of convenience must be held in favor of the injunction and should be presumed the plaintiff will suffer irreparable loss injury unless injunction is granted. So, my lord, this is, my lord, the test, my lord. This, my lord, flows down, my lord. I am very sorry, my lord. I show from my my lord, it has been some way mixed up because Mr. Kindly, my lord, reads from the tab. Once I give a hard copy, my lord, to my lord's court officer during it. This is 69 to SCC 727. This is not, my lord, coming today. It's coming from 69 to, my lord, the trademark was Rustam and Rustan. Rustam and Rustan, my lord. Kindly, my lord, have, my lord, paragraph 2, placitum H.
Yes.
On July 8, 1955, the appellant wrote to the attorney through a letter of the respondents, called upon it to cease and desist from using the mark Rustam on the engines, as it was infringement of the registered trademark Ruston. So, my lord, not similar, my lord. Phonetically, Rustam, Ruston. So, my lord, one change in the word. That's the reason, my lord, I am showing it, my lord. As the word Rustam India was used. So, my lord, one is Rustam India, one is Ruston. On February 17, 1956, the appellant instituted a suit playing for a permanent injunction restraining the respondents and his agents from infringing the trademark Rustam. On January 3, 1970, District Additional Judge Meerut sued holding there was no visual or phonetic similarity between Ruston and Rustam. The appellant took the matter in appeal in Allahabad High Court. By the judgment dated November 23, 1965, the High Court held that the word Rustam by the respondent constitute an infringement of the appellant's trademark Ruston, and the respondent should be prohibited from using the mark Rustam. But the High Court proceeded to hold that use of the word Rustam India would not be an infringement because the plaintiff's engine was manufactured in England and the defendant's engine was manufactured in India. The suffix India would be sufficient warning that the engine sold was not Rustam, engine manufactured in India, and respondents may be permitted to use Rustam India. So, my learned friend's case is he used 710 with his Metro. So, he can escape liability, So, A, this judgment, falls on the place. A, there is change of only one word, and addition of India, because Rustam is an English company and Rustam India is India, so he can do it. So, anti-dissection rule, 17 was not there, but this is how the Supreme Court, deals with. Now, Lordship will straight away, omit, kindly, takes, para 4 of the judgment in question.
Yes.
It is very often happens that although the defendant is not using the trademark of the plaintiff, the get-up of the defendant's group would be so much like the plaintiff that there's a clear passing off would be proved. It is on the contrary conceivable The defendant may be using the plaintiff's mark get up. The defendant's good may be different from the get up of the plaintiff goods, and the price are also different. There should not be probability of deception on the public. Nevertheless, in an action on a trademark, that is to say, in an infringement action, an injunction would issue as soon as it is proved the defendant is improperly using the plaintiff's trademark. This is 1969, Lordship. Now, kindly take paragraph 5. The action for infringement is a statutory right. It is dependent on the validity of the registration subject to other restrictions laid down under section 30, 34 and 35 of the Act. That's prior use. That should be generic, like in respect of Apple, I cannot get Apple. And 35 is own name defense or name of a predecessor. It's none in the present case. On the other hand, gist of passing of action, A is not entitled to represent his goods at that of B, but it is not necessary for B to prove that A knowingly or with the intent to deceive. It is enough that the get-up of the B's good has become distinctive of the goods of A. No case of actual deception or actual damage need be proved. A common law action is always maintainable unless there had been a fraud on the part A, on A's part. The equity, however, of Lord such and such, in fraudulent or not, using the plaintiff's mark and granted an injunction, and accordingly, the common law courts, however, added to their view that fraud was necessary until the judicature, but fusing the law and equity gave the equitable rule victory over the common law. Now, Lordship will kindly takes paragraph 6. The statute law relating to infringement on the trademark is based on the fundamental idea as to the law relating to the passing of, but it differs from the law in two respects. Namely, it is concerned only with one method of passing off, namely use of the mark. 2. Statutory protection is absolute in the sense that once the mark is shown to offend, the user it cannot escape by showing that something outside the actual mark itself has distinguished the goods from those of the registered proprietor. Means, addition. Means, putting a word in. Accordingly, in the considered question of infringement of trademark, courts have held it is expressly provided by the Trademarks Act 1938, Section 4, that infringement takes place not merely by exact imitation, but by use of the mark so nearly resembling a registered trademark as to likely to deceive. In an action for infringement, para 7, where the defendant's marks is identical to the plaintiff's mark, the court will not inquire whether the infringement is likely to deceive or cause confusion, but where the alleged infringement consists of using the word, not the exact mark on the register, but something similar to it, the test of infringement is same in an action for passing off. Here, now Supreme Court in 2016 says passing off is a wider remedy. In other words, the test as to likelihood of conclusion or deception from arising similarity of the mark of both in infringement and passing off. In the present case, High Court has found that there is deceptive resemblance between the words Ruston and the word Rustam. Therefore, the use of the word Rustam constitutes an infringement of the plaintiff's trademark. The respondent has not brought an appeal against the judgment of the High Court on this point. It is therefore not open to him to challenge the finding. If the respondent's mark is deceptively similar to the appellant's mark, the word India is added to the respondent's mark is of no consequence. Yes. And the applicant is entitled to succeed. That is, what has been said, by in the present case. So, in this case, injunction was granted, fully.
Give the copy.
Yes, I just give a copy. I'm very sorry. Now, Lordship will now kindly have a look at HON'BLE. Just Lordship. Lordship, just one judgment, I show it from my Assam roofing 10 kindly takes a look. I just hand up from my tab, there was a case of Assam roofing, The defendants was asbestos and the plaintiff was selling cements. So plaintiff was asbestos, cement, defendants was selling asbestos. Trial court, I got an injunction, both where mark was Rhino. Supreme Court, division bench, a bench presided by the division bench, Justice Banerjee, vacating the order, saying it's not similar. Or the goods are different, you can't. Supreme Court says in this type of matter, inquiry is very limited. If someone is registered, the other party is not registered, normally an injunction should be granted. The only thing the defendant can get, he can pray to the court for disposing of the suits of the stock in question. Well, may I just hand up and give a copy? না না কিছু আনেন অনেক দিয়েছি আমার কাছে আমি দিয়ে দিচ্ছি আপনার আমার কাছেও this is this small limited inquiry Millard HON'BLE আর HON'BLE pro energy adine pro energy pro energy adine ano পাঠিয়েছিল বলছে পাঠিয়েছো ও বলছে পাঠায়নি yes so Millard, this is the limited Millard in limited scope Millard. That's same view. I don't want to multiplicate the authority. Lordship will kindly take Millard. The hour court Millard, single bench Millard, proactive. I have already cited Millard. I give my learned friend a citation, so you can give me the citation of the it's unreported. I'm giving you a copy. Millard, it's Khadim lifestyle Millard. I report. I give my learned friend a copy versus where Millard pro and proactive was held to be Millard identical because ideologically Millard these were different. My copy is bit marked. Lordship will kindly Millard takes Millard paragraphs 24 to 27. Yes, pro and proactive. আমি আপনাকে SMS করে দিচ্ছি না এটাও না SCC অনলাইনে আমি আপনাকে দিচ্ছি yes yes দুটোই দিই paragraphs 24 to 20 চেক করে নি ওরা বলছে পাই So Millard, though it's 20 para 25, I'm very sorry it's marked Millard.
Yes, I am reading. No problem.
I'm very sorry, Millard. I apologize. পাঠিয়ে দাও না নম্বরটা নিয়ে পাঠিয়ে দাও না কেন করছো
Yes.
And out of my curiosity, Lordship will also take 2 paragraphs of 1969 volume 2 SCC 131. I just give Millard hard copy. I just tick mark the paragraphs, Millard, in Lordship's hard copy. This Lordship must have read it, Millard, before.
Which paragraph you are relying upon?
Millard, kindly have a look at 63. This is a 3 bench. Millard, presided by Justice Sikri, Justice Bachawat, and Millard Justice. This is Millard, Mr. Bachawat's grandfather. Millard, Millard, kindly take Millard, HON'BLE and HON'BLE, Millard. Paragraph yes, 1, Lordship will find. 2 marks in question was HON'BLE and another was HON'BLE. Yeah. One is Millard Lord Shiva, one is a Vaishnavite Saint Millard. So ideologically both are different because one is Shiva's consort. 69 to SCC 131. 69 to SCC? Yes, 131. Check copy. Right. Millard para 2. HON'BLE and Sri HON'BLE and Sri HON'BLE are separate divinities. Sri HON'BLE was a Vaishnavite woman saint of Srivallupur Pular village and was deified because of her union with Lord Ranganatha. HON'BLE is a consort of Lord Shiva or Maheshwara. Now, my lord, kindly take paragraph 3, the bracket portion. Just below paragraph 3. In a composite mark, the distinctive work appearing in a play, an important word. The words always talk over the decide. This is because generally the word of a composite mark that an order will be given. Apart from the opponents have a registered mark consisting of the expression "see HON'BLE." I have therefore to determine whether the expression "see HON'BLE" is deceptively similar to "see HON'BLE." He held that the sound of HON'BLE does not really so resemble the sound of the mark HON'BLE, and in spite of certain letters being common in both the mark, as likely to cause confusion or deception among a substantial number of the public. This was Millard the decision. Now Millard kindly takes the Supreme Court view. Millard para 6 at page 134, placitum B. We have no doubt in our mind that if the proposed mark is a normal and fair manner, the mark would come to be known by its distinguishing feature HON'BLE. There is a striking similarity and affinity of sound between the words HON'BLE and HON'BLE. Giving it due weightage to the judgment of the register and bearing in mind of the conclusion of the learned single judge and division bench, we are satisfied that really a danger of confusion between the two marks. Now paragraph 7. There is no evidence, paragraph 7, of actual confusion, but that might be due to the fact that the appellant's trademark is of not long standing. There is no visual resemblance between the two marks, but the ocular comparison is not always the decisive test. The resemblance between the two marks must be considered with reference to the ear as well as the eye. There is close affinity of sound between HON'BLE and HON'BLE. Now, we'll at para 9. The name HON'BLE does not cease to be deceptively similar because it is used in conjunction with a pictorial device. The case of Diprova versus Vicks, the instructive form of the appendix printed, such and such the same volume appears to be Vicks Chemical Company, where the proprietors of a registered trademark consist of the words Vaporub, and another registered mark consisting of a design of the words Vicks Vaporub forms a part. The appendix at P 220 shows that the defendants advertised the common or Carsole Vicks Vaporub. It was held that the defendants had infringed the trademark. Lord Radcliffe said the trademark is infringed by the another even without using it as a whole or upon it in connection with the goods if he uses one or more essential feature. This was what I was telling in the morning, Millard. This is the judgment laws. This is not in the section. Now, Millard, kindly take page 10. After Mr. Ashok Sen's argument, Millard, kindly take H. In case of Neville J, held that the words limit, just I, Millard, paragraph 10. In that case, Neville J held that the word limit and summit were the words common use and even conveying a definitely idea. There was no possibility of one being deceived by the two marks. There is no ground of refusing registration. Mr. Sen arguments loses the sights of the reality of the case. The Hindus in South India are made well aware of the words of HON'BLE and HON'BLE, represent the two names for distinct goddess, but the respondents' customers are not confined to Hindus alone. Many of the customer Christian pastors and Muslims are there. Moreover, there the business is not confined to India. Of the customers are not Hindus who do not belong to South. The words have no direct reference and character to the goods. The customer who use the respondents' goods will have a recollection that they know the word HON'BLE. They might be a vague recollection of the portrait of the mark, and these are not like to remember the distinctiveness between the Vaishnavi goddess and the Shivaite deity. An injunction, and it was said it was deceptively similar. Now, Millard, do not have to go any further. In his affidavit in opposition, this Millard showed at the time I handed up of Millard the respondent to the application, a show cause notice was issued. That's page 80 of the affidavit in opposition to the main application, Millard, of GA1 of Millard the defendant, wherein the mark Millard, my mark, Metro at page 31 was cited as a deceptively similar mark.
Yes.
As a deceptively similar mark. In this context, Millard, and thereafter, Millard, the 120 days gone, and I could not file the opposition. That cannot be a ground of Millard denying me an injunction. I have already filed a rectification, my lord. This, and in this context, my lord, I'll be praying for an injunction on the mark.
When
I have
you file the rectification?
my lord, rectification I filed for it, sir. Lord, I just give the dates. Lordship will kindly give. Give me 1 minute, my lord.
Now, 31 is the opposition. But
Yes.
the department.
Oh, it's opposition, not rectification. That's the other matter. It's a opposition stage has not yet, my lord. Someone else has opposed. If my lord, if my lord, if it's registered, I'll go for rectification. The mark is not registered, my lord. I'm very sorry, my lord. I mixed it up with the other matter in the board, my lord. Next board. So, my lord, my lord, if he gets a registration, I'll go and file a rectification, my lord. I have a claim in passing off also. These are my respectful submissions. Grateful. May I have a lordship please for 1 minute for the next.
My lord is hearing not only the vacating applications, but the entire the injunction applications, since all the affidavits have been exchanged. That firstly, that I just rely on their averments. The entire controversy, lot of ratios have been laid down by the Honorable Supreme Court. I also cite the authorities. But the main matter is very short. As it has been pointed out, whether the word, kindly take note of it. It's capital M, then small CTRO. That is MCTRO. My learned friend is pronouncing it as metro. Now, whether this is phonetically similar and there is deceptive similarity so as to cause infringement under Section 20. That's the crux of the matter. Now, in order to decide that issue, just at a glance, kindly have a look of the marks of the my learned friend and also my one. Kindly see, kindly take my affidavit in opposition to the main injunction application, which is affirmed on 30th July 2024.
Yes.
Malad has got it. Kindly comes to page 24 first. This is my learned friend's contention, my learned friend's registered mark. It's their writing, not in capital, small m, then capital ETRO. Kindly mark the style also. It is admitted position and settled law that the stylized manner and the use of the capital letter, small letter makes a lot of difference. Your lordship is deciding whether this is phonetically similar, sound is similar. Then also this resembles, there is nearly resembles the word. Now this page 24, small m, then capital TRO, just on a plain reading, that on a plain look, that by a man of ordinary prudence, kindly compare this page 23. This is my mark. Capital M, then small CTRO. Style is also different. My lord has gone through the different cases where.
What is your pronunciation?
That is pronounced mactro, not metro. MC when there is mactro. But I have checked up that personally that from the devices, the pronunciation is mactro, it's not metro. MCTRO, not on a plain look at the by a man of ordinary prudence, this is not similar, deceptively similar, far less not deceptively similar. MCTRO 710. Now, what is their case on the plane?
Metro is M is small.
Yes, there's my is C.
No, M.
There is capital.
There M is
capital.
Capital.
Capital. There your lordship can funds take their registration. They are saying M capital, E capital, but they are using it at small m at page 24.
That's what I'm telling.
Yes. This m is small, as it looks subject to corrections.
Because they are okay.
Yes, I take it as capital METR. So, kindly takes the plain averment on the plaint. Kindly takes the plaint. There also your lordship will find the mark, page 58 and 60. They are marked plaint page 58.
Print is not here.
It's a petition print.
Print is not enclosed in the petition.
No, it is in the brief, my lord's brief, probably not. Lordship is
Print is enclosed in the petition, no?
no, not petition. GA1, I think. GA1.
Yeah, GA1.
GA1. Well, kindly text to me at page 50, page 58, my lord. But the earlier affidavit in opposition, page 23 and 24, I have showed this is exactly photograph of the goods, plywood. This is marked on this product. This is the exact the use of the two marks by my client and by my learned friend's client. Now, this is officially what is that there? What is the trademark registered? Page 60.
No, page 58 is a metro.
Page 60 also. Page 58 and page 60.
Page 60 metro.
GA, yes. This is metro there.
And that page 60 is the copyright.
Copyright. And page 60
is the copyright and page 58 is the trademark.
Trademark.
Label mark.
And mine one, as it is shown from the affidavit of opposition, page 61, the next document, page 61. So distinctly, my lord, this is capital MCTRO, pronunciation is different, style is different, and the manner of the use is also different. Not only the adding the suffix by 710. Now kindly comes to the averment which they have not used in their the plaint. That kindly comes to paragraph 12 and 13
of the application.
Of the application, page 7. Now that G1. G1.
Yes.
Paragraph 12, they use my mark as capital MCTRO710.
Correct.
So wrong description of my mark in the plaint on the basis of they stated that this is, and that's why my learned friend is constantly pronouncing it as metro. His own pronunciation I would do, but by common parlance, what is the phonetic sound of MCTRO, that is not relevant. That when MCTRO, like not MC, then when we use, then this is Mac. McDonald, all the K is added there.
So your case is that M is capital, CTRO
yes,
is small.
Not just coming to this, I challenge this order in the division bench. One of the single judge or one of the judges, said that why are you affecting? You use that word MCTRO. But I said that no, since the matter is subject, before my learned friend, I will clarify it, bro. So this is their case that my mark is MCTRO capital. It's not that. Now coming to the I am grateful to my learned friend that which my learned friend has referred to his documents. Kindly takes my the vacating application. The different marks used by the different entities. The metro. Why I submit? Because this particular word, as your lordship knows, metro is dictionary, any dictionary meaning either black or not any legal dictionary. There are two meanings ascribed to it. One is underground railway, and another is this is a big town or city. So it's a generic word. The dictionary shows that there are two meanings of this word. So this word, in my respective submissions, was subject to correction. This is a public juris, generic word, general word. There cannot be any exclusive right of the plaintiff over this word. That's why I am corroborated by this fact of page 26 of my the vacating application. Page 26 of my vacating application, GA3. GA3, had there been exclusivity given to the plaintiff, then no other entity would have got the registration of the word metro and another words. The lordship has seen page 26, the first one, clause under clause, has the lordship got it, page 26. So under clause 19, the my learned friend's clients has got registered. This is the plywood product, and then page 27, registered metro gold. So all these contentions that metro, they have the exclusive right and no other person can use this word, even it is capital, metro gold. So this is registered. Considering the fact this is a public generis, it's a general word. So that's why there can't be exclusivity of this. That's why it is registered. Not only this one, my learned friend has also placed this page 28 label mark. Page 28 bottom is also plywood, is also registered. And my lord will find similar Rebel here, Metro, this style is also same. Page 28, not bottom. Page 28, bottom, the style of my learned friends, not trademark, is absolutely similar with this Metro ply.
Which one?
Page 29, the
Page
last
28,
one, this is my learned friend, my
page
learned
20.
friend's own, and then this is not the Metro is used by not another entity as page 27, as I showed, and my learned friend's Metro ply, and then this is page 29. Some rectifications filed, but after rectification, this is also, and some was registered, some are opposed. So admittedly, even in one case, one party is allowed to use this particular word Metro. It's a general word. There cannot be exclusivity of this. Then without page 30 also, another entity, without Harish Rungta, it's objected. So it's before the registering authority. As this is a general word, there is no exclusivity ascribed to it. So other entities are also using, and they have got the registration of this mark. And the word of those entities also, that more or less, not Metro word is there and capital. It's capital. Mine is absolutely different. Now my note kindly comes to, my learned friend said that the invoices and the why I have used this particular word MCTRO, that my learned friend says that I have got the inspiration of that company, American company. I never said that I have been using this technology in none of my averments in the affidavit opposition or in application. I am not saying that I am not using that issue. And that BIS 10 certificate, that is not as a mark of reference, I have annexed, but it is not extended, renewed from time to time, it is valid. Since this is not under challenge, but I have not annexed. Just as a mark of reference, why I'm using this 710, because I'm registered under BIS, that mark is 710. That's why I use that. Now, kindly comes to one or two invoices. Kindly take my affidavit opposition to the GA1 injunction application, page 22.
Yes.
Page 22, just one invoice. It's dated 29/2/2024. My lord has noted the application is May 2023, 27 May. This is one invoice. Kindly see the mark used to supply such and such commercial plywood MCTRO 710. So this is, we are not using that METRO Metro as contended by learned friend. Then my learned friend also contended as if the section 11 proceedings, when the notice of opposition was given, that finding is whether sacrosanct. It's a prima facie interim stage. Everybody has got right to object when it is advertised. The competing parties may object, and my learned friend will also kindly see what is the notice of objection and other brands. Kindly take that opposition, that's same document, page 34. Page 34. It was published on June 2023. This notice of opposition, advertisement was published, and then this is the grounds of objection given by one of the parties, in which my learned friend did not participate.
When it was published, where is the date?
Yes, this is page 28.
You
16/6/2023.
No,
This is
you
one.
you have referred the page 34.
Yes, page 34.
What is the page 34?
34 is the grounds of opposition to my mark used, that is filed by another party, which my learned friend did not participate. There the parties are producer of goods, shoe goods, Metro shoes, Metro bands, which manufacture shoes and other allied products. Metro word is not only used by this shoe products, other companies using ice cream also. So Metro is a common word. Now there, your worship, you just will find that page 37, that these are the marks used by Metro. Different marks registered by that company. One of my contentions is that I have taken registration of different marks. Why have been using that? Law doesn't debar me to use the mark which is not deceptively similar. So these are the marks, and they are also page 38 in the notice of objection. They are also wrong description of my mark. This is METRO they have mentioned, page 38. My learned friend all along has been contended that it is METRO. So this is not the factual aspect. So there is wrong description in the plane. Now coming to the laws, authorities, I have tried to search out just several authorities. My learned friend, I'll deal with the cases cited by my learned friend. Now this is one of the cases where the Subway is a reputed brand your lordship must have seen in the airport that makes the sandwiches and burgers. So there is a dispute in the Delhi High Court whether the Subway and the Vacating delight whether these are deceptively similar or not. Thereafter, some changes were also made. Thereafter, also the Honorable Delhi High Court, considering the earlier decisions, held it that this is not a deceptively similar, injunction was vacated. But kindly see page paragraph 2. But what was the plaintiff's mark there? Paragraph 2, it's Subway and Subway. And this is, the chart is showing different marks obtained by that particular company, the plaintiff therein. And the defendant, there also the plaintiff's claim was that they have exclusivity over the word Subway and Veggie Delight and Subway Club. Now, different defendants kindly see the contentions of the plaintiffs therein at page paragraph 6, that the defendants brand Suburb, under which 2 restaurants run by defendant number 1 in Delhi operate with an identical yellow and green color scheme on the use of the Veggie Delicious sub on a club, which according to the plaintiff are deceptively similar to the plaintiff's registered Veggie Delight and Subway Club marks. So these are the contentions. Then there are some changes which was suggested, and that was also done. That is paragraph 12 of that judgment. There's a comparison of those marks are there. Paragraph 12. The first one is plaintiff, the defendant before change suburb and after change suburb. The word remains same, just style makes a little bit of difference, but the word same. And ACE logo is also not changed. So in that factual scenario, the Honorable Delhi High Court, they considered the different authorities on the field cited by different parties. There, kindly comes to paragraph 18. This is the analysis. This court is presently concerned in an application filed by the plaintiff under Order 39, Rule 1 and 2 CPC with whether, after the modifications that the defendants have undertaken, the defendants can still be said to be infringing the plaintiff registered trademark or passing off their goods and services as those of the plaintiff so as to entitle the plaintiff to an injunction. Why that will rise? Or?
Yes, continue.
I'll continue.
I ask you whether it is urgency.
But
because
there is,
due to you, other injunction application is lying.
I'll be very short since my learned friend has cited decisions. I'll just take very short.
Okay, complete.
Today I'll complete my citation so that he can also reply. The infringement under section 29(1) to 5 of the Trademarks Act can only be registered trademarks, the marks of which plaintiff has subsisting registration, which are entitled consequently such and such. Plaintiff has no other registered trademark. Now, my learned friends contents of section 17(2) anti-dissection rule doesn't apply here. He cited the authority, but the authoritative decision is not that the section 17(2) does not apply and the theory of anti-dissection rule does not apply. Dissection was section 17 quoted here. Dissection of a trademark and claiming exclusivity in respect of the mark, or the claiming infringement in respect of any matter which is common to the trade or otherwise of a non-distinctive character, publicly juris. That is my contention. The judgment of the division bench of this court in South India such and such has however subjected to anti-dissection rule to a caveat, where a part of a mark constitutes its dominant feature and is distinctive in nature or has acquired secondary meaning by dint of long uses. The relevant passages from the decision may be reproduced such and such. But I did not trouble your lordship. The crux of the matter is that whether the ratio is that that you have to read the mark as a whole. You cannot dissect a part of it and claim the exclusivity of it. That's the ratio. Now, paragraph 22. The court has therefore to consider whether as a whole the mark of the defendant infringes the registered trademarks of the plaintiff. If they do not, then the court may examine whether, if any part of the plaintiff registered trademarks which constitute the dominant part thereof stands so infringed by the defendant's mark. The word mark subway and the device marks of the plaintiff, to my mind, it is clear that the defendant's mark cannot be said in any manner by of speaking to infringe any of the plaintiff's word marks or device marks. Suburb is not phonetically similar to subway, though both are words of two syllables. The first syllable sub is common. Sub, when used in the context of sandwiches, it is well known, is an abbreviation of submarine, which represents a well-known variety of long-bodied sandwiches, generally 6 to 9 inches in length. Submarine sandwich has, in fact, its own Wikipedia page that I am not troubling with, Lordship. Now, the final conclusion, that page 23, paragraph 23.3, this middle paragraph. In fact, the submarine limited the petitioner in such and such judgments on which such and such reliance also deal with outlets serving submarine sandwiches. The very little of franchises, Mr. Submarine testifies to commodity of the usage submarine as a moniker for sandwiches of particular type. Sub is therefore publicly juris when used in the context of such juris. My submission is metro is not the, it's a publicly juris. No exclusivity, paragraph 23.4. can therefore be claimed by the petitioner over the first part of his registered subway mark, that is sub. The plaintiff cannot claim a monopoly over all two-syllable words of which the first syllable is sub, especially when used in the context of eateries which serve sandwiches and similar items. Once thus the sub part of the subway mark is out of the way, there is quite obviously no similarity at all between the way and the herb. The use stands covered by the judgment of the Honorable Supreme Court in J.R. Kapur's the celebrated judgment, but I'll also cite that, on which Mr. Such and Such relies upon. J.R. Kapur deals with the completing words micronix and microtel, of which first syllable micro was found to be descriptive of the products in which parties dealt. The Supreme Court held, therefore, that no exclusivity could be claimed over the prefix micro, and that as the suffixes nix and tel were dissimilar phonetically or otherwise, no infringement could be alleged. In paragraph 6, quoted. Paragraph 6 quoted, I just read 2 lines from that paragraph, and the next page, that is running page 19. Secondly, these words starting from secondly. Secondly, even the visual impression, that has his lordship got it. Secondly, the visual impression of the say two trade names is different. In the first instance, the respondent's trade name Micronis is in black and white in similar letters, and they are ensconced in designs of elongated triangles both above and below the same. I do not elaborate further. The style and manner, my very short submission, the style and manner of the words MCTRO and that of the mark of the petitioner plaintiff is absolutely different, even visually, phonetically absolutely different. So, their lordships held that this is not infringement. And then paragraph 23.8 also, the division benches of this court have also held that the same effect in such and such the competent marks were meronym and meromar. Absolutely though seem to be similar, used for pharmaceutical preparations containing metropenem. The court found that the suffix mero, when used in such preparations, was an acronym for meropenem and was therefore descriptive and public juris. Name and mere word, it was held not to be phonetically or otherwise similar. The plea of infringement was therefore rejected. Paragraph 19 of the report. I trouble your lordship is then the paragraph 23 final conclusion. That's these are not deceptively similar, and the word that subway and the club is also public juris, and ultimately the injunction was vacated. But that is the decisions.
Yes.
Then this is another judgment of the Delhi High Court.
How much time you will take?
But may I come back then? But dealing with his decisions also. But I just give me the citations through my learned friend so that he can also consider.
Item number 14
the interim.
They are not completed, sir.
I'm sorry.
You being the seniors, sir.
I'm sorry. I apologize.
So and so suffering for the plaintiff, so and so suffering for the defendant. Plaintiff has filed an application for grant being GA 1, 2024 for praying for injunction, wherein this court has granted identity. The defendant has filed an application being GA 3 of 2024, for vacating the interim order. Counsel for the plaintiff has concluded his argument with respect to both the application. Counsel for the defendant has argued the matter, argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear. आज कितना तारीख है 23 30 टाइम क्या है there's no time. How?
No, I leave it to your lordship. I leave it to your lordship. I know the program of your lordship's but I will take just half an hour more. That's all.
4th October under this heading, same heading.
Lordship is keeping it on
4th.
Obliged.
Interim order is there.
Yes, still 4. Obliged.
Would your lordship
Yes.
me to mention a matter which can be disposed of for the time being? Lord, it's item number 16. Lord, on the last day, your lordship had not passed an order asking them to take instructions whether they'll give a undertaking in terms of their own letters, which was at page 242 of my petition. I'll just hand it up, Lord. My learned friend has agreed to this.
Who is appearing?
Lord, my learned friend, Lord, Mr.
My
Bhattacharya.
advocate on record was. Where is that instruction?
And I understand from my learned friend that he's agreeable to give it. So that's why.
My advocate on record. Shoghi Kundu.
তো তোকে তুমি বলেছিলে
Yes.
Lord, I understand my learned friend was agreeable.
No, I have to see whether those instructions have come from the client.
Why did you ask? Lord, I'm sorry, Lord, I mentioned it. Lord,
No.
Lord, I understood that he was.
What is your instruction?
I'll see what instructions. But this would.
Lord, my learned friend is also here for another defendant. He was to take instruction.
For defendant number 2.
So far as defendant 1 is concerned, this is our instruction in writing, but without prejudice to my rights and contention that the suit is not maintainable.
Yes. Lord, do that. Give directions for affidavits.
I had sought for an accommodation and Mr. Bachawat accommodated me that day. So that's why I did not file the 12-way till this matter was taken up.
So now what? There's an injunction?
No, Lord,
they want an undertaking in terms of this email.
Lord, it's no point arguing a matter like this before the vacation. That's why I said I asked my learned friend to take instructions whether he's agreeable to not comply with this.
Have you gone through this letter?
Lord, he has a copy. Yes. Lord, it's not acceptable. Lord, my learned friend for defendant number 2 was also to take similar instructions. Lord,
My instruction is that I am not privy to any confidential information. So, there is nothing to undertake that I'll not divulge or further divulge anything like that. I'll have to take instruction whether I can give any written undertaking to the court that I will not divulge anymore because I was never privy. That's
What is your submission now?
Submission is I was never privy to any confidential information.
Lord, he has signed a confidentiality agreement, which is a annexure.
I can show if Mr. Bachawat wants to argue that day he wanted this.
I don't want
he
to
wanted this instruction. I can show
your lordship will record. No point.
Yes.
Lord, my learned friend is giving the undertaking record that the defendant number 2 has refused to give such an undertaking. That's all. Lord. For the time being, give directions for affidavits, and Lord, I'll come back and fight it out after the vacation.
Without prejudice that the suit is
yes.
So and so, 60. So and so offering for the plaintiff, so and so offering for the defendant. Full stop. Counsel for the defendant number 1 has handed over a communication dated 16 September 2024, wherein the defendant number 1 has informed the learned counsel for the learned advocate on record that invert comma without prejudice to our rights and contention of this matter, we are willing to give undertaking in terms of the email dated 11th December 2023. What is the 11th December? This one.
My lord.
11 December
My lord,
2023.
I'll just copy later. My lord, kindly gives me a moment. My lord.
My lord, I haven't followed. My lord,
In that, they're telling the 11th December 2020.
but that's the page I've given to you.
My lord,
Lordship.
that's
Page
page
242. 242. My lord.
This,
Yes.
the 11th December 2020 and the email dated 11 December 2023 reads as follows. This one then full stop. Page 242. In view of the full stop, the counsel for the defendant number 2 submit that he has not received any instructions and he is not in position to give any written instruction. Written instruction. Full stop. Full stop. In view of the above, in view of the communication dated 16 September 2024, without prejudice to the rights and contention of the parties are directed to file their affidavit in opposition
2 weeks after vacation.
2 weeks after vacation.
2 weeks
Reply, if
thereafter.
any, they are to be filed within 2 weeks.
2 weeks thereafter.
2 weeks thereafter. Please the matter on 3rd of December 2022.
Oblige.
My lord, so far
not 3rd, 5 खुलते हैं ना, 4 खुलेगा. 4 खुलेगा. 9th December.
Lord, may I have my lord's kind leave? My lord, may I have my lord's kind leave to mention item number 14, Mr. Bachawat. My lord, the interim order is expiring today.
40?
Lord,
Yes.
this is a new life. Lord, your lordship will not please extend it. Not if at all for 1 day. Lord, I'd already
In the
made
order
my
copy?
arguments. Lord,
Order copy.
Lord, please.
My lord, let the receivers be directed to. My lord, it's still 30th of
Lord,
September.
if it's possible, please fix it tomorrow. Lord, my business
Yes, I have no difficulty.
completely not come.
My lord,
to
no,
an
no,
order.
no, no. My
Lord,
lord,
I
he's in
finished my.
contempt. He's
Your
in
lordship will
contempt.
remember I had finished my submissions. If my learned friend's best point is that, well, there's a contempt and therefore
No, no.
continue the
My lord,
interim
my
order.
lord, this is
Lord, I'll
argued
have-
by Mr.
I'll have-
Bachawat, an injunction on trademark.
Maybe.
Your lordship, just 2 lines.
Lord,
2
there's
lines.
no injunction on the
Just-
corporate name here. Lord,
2
here my
lines.
learned friend has got an injunction on my corporate
It
name.
is marked, my lord.
Yes,
It's-
yes. Have a look at those 2 lines and I'll show your lordship. Lord, my learned friend can't take the shelter of this. Lord, how does this stop anyone's business? All he had to do was change the color of his battery.
So what you want?
Lord,
But
please
can you
keep
fix
it
it
tomorrow, Lord. I had finished my arguments, Lord. I'm suffering an interim order against my corporate name.
So and so offering for the plaintiff, so and so offering for
Lord,
the
that homeopathy matter, your lordship will remember.
and the special officer appointed by this court is also present.
My lord, he is one of the special officers. There are
One of
2
the
more.
special officer, namely
Mr. Altama Salim.
Altama Salim is present and has filed the report. Have you served the copy? After circulating the counsel for
For defense. For defense. For us. Hadhi.
counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and placed for extension of the interim order. Also, counsel for the defendant submit that the defendant is facing difficulties due to the interim order placed by this court and praying for fixing the matter tomorrow. In view of the submission made by the
Item
counsel
number
for the
Item number 14.
the interim order granted earlier is extended till 4th of October 2024 or until further orders whichever earlier. Let the matter appear on 3rd October 2024. Third.
Is it possible to keep it to 1 minute? I tell your lordship, I wouldn't have made any unreasonable request, but my business, Lord, we are from Bhopal, they are coming down from there every time.
At the top has parted.
And my lord, other special officers be directed to circulate their reports.
The other special officer are directed to file their report after circulating the same to the learned counsel.
Where have a lordship standing similar interim order is still today, my lord. I have
Item 89. Which one?
89 was Saj, my lord.
89.
My lord, I have one submission, my lord. Interim order is still today.
Item number?
89, 90. Full start.
Item number?
89 and 90, lordship. I am mentioning it was extended once.
Your lordship is aware, my lord, we are suffering an interim order. Mr. Mukherjee has
Mr. Bachawat has got a little some. I am not on that. But the only thing is that your lordship kindly keeps it on Thursday or Friday, but only for one reason, not for the completion also. But if some midway solution can be arrived at, that we'll be able to dispose of the stock or something by giving our stock register and something like that, so that a midway at least, because it's a biscuit. It has a shelf
Wait,
life.
you are
it's going to
appealing?
get
I'm appealing.
destroyed.
Interim order is still today. Keeps it any date convenient to your lordship.
I'm
No,
saying
he is
for
telling
this
that
reason.
with regard to
I'll
interim
take
order,
instruction.
what the
One
materials
thing-
are with
That's why I'm
them,
saying that
they
shelf
wanted to
life will
dispose
get
of.
destroyed.
Let
let us let lordship will extend the keep it on such. I'll take instruction and come by. Come by.
29, 89 and 90. Sense appearing for the plaintiff, sense appearing for the defendant, counsel for the plaintiff submits that the interim order passed earlier is going to be expired today and pays for extension of the interim order. Counsel for the defendant submits that a short date may be given so that an interim arrangement can be made so as to enable the defendant to dispose of the available materials.
Current stock
Which are available.
The stock register or the stock whatever.
Which are available with the defendant. Full stop. In view of the submission made by the counsel from the respective parties, the interim order granted earlier is extended till 7th of October 2024.
And so far as this part is concerned, I'll take instruction.
Or until further order. Full stop. The counsel for the plaintiff is directed to take instructions to the suggestion made by the counsel for the defendant. Let the matter appear on 4th of October as under the heading parted.
Interim order lordship is extended
At the top. On 7th, I am fixed. Interim order
was still till today.
till 7th.
But by
On 4th. If this arrangement is made, then I will.
Maybe on the
but another extension,
Third other Mr. Bachawat.
well, another extension of interim order. Another extension of interim order expiring today, 30th. Item number 12.
Who is for the other side?
Well, there are advocates from outside. I do not know any of them. There is no wakalatnama filed. I checked in the records.
Item number?
12. Commercial cases.
Sense appearing for the plaintiff and appearance
Expiring today.
the interim order granted earlier is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff as the interim order is going to be expired today, accordingly the interim order is extended till 22nd of November 2024 or until further order whichever is
Till 7th of November.
22nd.
22nd.
May I have my lords leave to mention item 18 of my lords this minute. I was beseeching my lords for an ex parte ad interim order.
Item number 8.
18, 1/8 minute. May this be much
It will
before
be remain in the list tomorrow. It will come.
but I'll be some difficulty next week. And
Huh?
minute,
No, tomorrow it will come.
some precedents because it's an ex parte ad interim order.
All are precedents.
Minute, all these matters are coming after affidavits or even after some precedents. Minute.
Item number
18, 1/8.
What are the other matters prior to 18?
This one is an expert. I'll be moving an ex parte ad interim order.
Yes.
Deeply obliged. Deeply obliged.
Against Fovena. So then.
Item number 10, if your lordship permits me, my lord, because it is already 1:40, I do not want to detain your lordship, my lord, unnecessarily. But item number 10, the next matter, but I am appearing for the respondent, my lord. We were out of time, my lord, to file the affidavit in opposition. We have served it upon the petitioner. My lord, they will, my lord,
My lord, this time to file affidavit in opposition was given by my lord on 26th of April 2024. 3 extensions have been obtained. And my lord, my learned friend is not correct in saying on 7th September, we received a copy of the affidavit in opposition from the erstwhile advocate on record. Thereafter, my lord, that was affirmed on 5th of September, the affidavit in opposition. Now, my learned friend, my lord, on 22nd of September, my lord, has served another set of affidavit in opposition affirmed on 13th of September. My lord, my learned friend's client has affirmed 2 different sets of affidavit in opposition.
my
Both
learned
equally
senior is absolutely
voluminous.
correct. My client has affirmed 2 sets of opposition, but I am only filing one before your lordship. And as on date, my lord, my advocate.
Where is the affidavit?
But it's here, it's
Well,
ready.
it gives
Yes.
So, my lord, to
I've served
which-
them a
I
copy,
asked
my
this question to myself, to which affidavit in opposition do we give
But
a
the one that is
retraction?
being filed.
My lord, well, they are retracting from the earlier.
So I am recording the date of affirmation.
Yes, my lord.
absolutely.
I am recording the date of affirmation.
Absolutely.
Take the copy.
But
and
we've
you
already
have to-
served.
They've
We've already,
served upon us,
we've
my
already served.
What is the date of the affirmation?
13th of September, my lord.
So and so appearing for the plaintiff, so and so
Amen.
appearing. Is a plain suit or
My,
affidavit?
no, my lord, it's an application, my lord.
So and so appearing for the
For cancellation of my learned friend's
So
registration.
and so appearing for the petitioner, so and so appearing for the respondent. Police counsel for the respondent submit that his affidavit is ready and he may be allowed to file the same as the defendant, as the respondent is out of time to file affidavit in opposition. Police counsel for the petitioner raised objection and submitted that she has received an email from the erstwhile advocate on 7th of September 2024, wherein affidavit in opposition along with the annexes on behalf of the respondent number 1 was served upon her. Full stop. Now the learned counsel for the plaintiffs and defendant submitted that the defendant is harping upon the affidavit in opposition affirmed on
13th of September, my lord.
13th of September 2024, and the copy of the same has also been served upon the counsel for the petitioner. Full stop. In view of the above, the affidavit in opposition affirmed by the defendant number 1 on 13th of September 2021 we kept with the record.
My lord, I was humbly praying for 3 weeks after the vacation since the clients, and you can, my lord, one more indulgence, my lord. All points we kept open because both the affidavits are contradictory and both have been affirmed by my learned friend's client.
The counsel for the plaintiff petitioner prays for 3 weeks time after the puja vacation to file affidavit in reply. Let
Without
affidavit in reply be filed within 3 weeks after puja vacation. The question of maintainability of the affidavit in opposition filed by the defendant and affirmed by the defendant on 13th September
Yes,
2024 be kept open.
Grateful, man.
Will your lordship record the affidavit of service reflecting service upon the
I
petitioner?
accept service,
Very,
my lord.
very,
I accept
but not required. Grateful to you.
3 weeks after.
Yes.
My lord, we had mentioned this matter, my lord, an originating summons originally supposed to have come up on the 3rd, but I believe, lordship, the summons could not be completed by the department.
Yes, only 24 the department has received. They asked for the time for extension.
Lordship, so may it come up on the 8th, lordship?
I am fixing 15 days after vacation, after 2 weeks.
My lord, there is some urgency, my lord. Only 8 days are required in between.
There are so many matters. All
Well,
matters
this is a very short matter, lordship.
the matter is listed as to be mentioned on the report of the master and official referee. By an order dated 18 September 2020, by an order dated 18 September 2024, this court has directed the plaintiff to take appropriate step for issuance of writ of summons upon the defendant within a week, and the matter to appear on 3rd of October 2024. It is found from the report that the department has completed the scrutiny only on 24th of September 2024 and prayed for extension of time. We have received the department 24 for the purpose of scrutiny of the same and prayed for extension of the time. He received the record on 24th of September 2024 at 4:10 p.m. for the purpose of scrutiny of the same. The department has prayed for time for taking appropriate steps. In view of the above, that the summon be issued upon the defendant, returnable after 2 weeks of the puja. Yes, next.
My lord, could it be 10 days? One
department is not there. What can be done?
Lordship. Great.
Yes.
My lord, I appear for the officer in charge, Jorashaka Police Station.
Huh?
I appear for the state, my lord, the officer in charge, Jorashaka Police Station, my lord, the defendant number 4 in the suit, my lord. This is possibly an application for restoration, my lord.
Who is for the plaintiff?
My lord, I am for the plaintiff, my lord.
Yes.
My lord, in view of the resolution of the bar, my lord, let the matter be taken up on tomorrow, my lord.
Not today.
Not today.
Next.
My lord, 2-3 same matters, my lord.
Which matters? 2-3 set matter. Give the serial number.
My lord, serial number 2 and 3, my lord.
2 and 3, not today. Yes, next.
Lordship, I'm for the defendant, Lordship. Lordship, this was the legal aid matter. Unfortunately, the defendant could not come down to sign the Vakalatnama owing to her illness. She has been advised not to travel by the doctor.
Correct.
Lordship, may kindly keep this matter after the
For the
vacation.
plaintiff.
Plaintiff, no one is appearing today.
So you not filed the Vakalatnama?
Could not, your Lordship. Our hands are tied.
12 September also you have taken time.
Lordship, the defendant could not come down, Lordship. She has been advised not to travel by the doctor. A medical certificate has been given to her. Can take the leave.
As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 13th November 2024. Next.
Deeply obliged, Lordship.
Lordship, I appear for the plaintiff, Lordship, in this matter.
Lordship, we filed a new GA application. Lordship, in that we are seeking an order directing the suit to be placed in the list of undefended suit.
You are for the plaintiff.
I'm for the
Why
plaintiff.
undefended suit?
Lordship, even after 28 days of the service of summons, Lordship, they have not filed
When the notice was served, where is the report?
Lordship.
For that you filed an application.
Lordship.
Good.
Lordship, writ of summons have been served on 26th August 2024, page 21, Lordship.
Served on 23rd of August. No.
26th of August 2024.
6th of August.
28 days have passed, Lordship.
How many defendants? Sole?
Lordship, 2 defendants.
2 defendants. So,
Lordship, 28 days has expired on 23rd September 2024. Thereafter, we filed
no,
this
but
application.
through the
And
process server, it was on
Lordship.
31st of August. Have you the report?
Lordship, I have
And
the
you
report.
come to the first column. First column. Served on 31st of August at 10 a.m. upon the defendant number 2 for self and
Lordship, thereafter service through post with AD.
Service AD on 23rd of
26th August
26th
2024.
So
I've considered 26th August, Lordship, because it's the first service.
Okay, then
Lordship, Lordship sees page 23. Lordship, 24 states that
entered appearance on it neither through
Lordship, page 25, where the deputy registrar legal says that up to 25th day of September, there has been no written statement that has been filed.
28.
25.
25. No written statement filed on 25th of September. Yes. That's all.
Lordship.
So and so appearing for the plaintiff. Plaintiff has filed the present application being GA 5 of 2024. Praying for placed CS numbers 172 of 2024 in the list of undefended suit. Counsel for the plaintiff submitted and the writ of summons was served upon the defendants through serif on 31st of August 2024 and by post on 26th of August 2024. After receipt of the writ of summons, the defendants have entered appearance through the learned advocate on 11th of September 2024. Full stop. The plaintiff has also obtained report from the Deputy Registrar Legal dated 25th of September 2024, wherein it is certified that no written statement on behalf of the defendants have been admitted by the London Master and official referee till 25th of September 2024 as per the information provided by the office of the London Master. Consider the submission made by the counsel for the plaintiff, peruse the reports. This court finds that in spite, though the defendant have entered appearance after receipt of the writ of summons, but have not filed written statement. Accordingly, CS number 172 of 2024 be placed in the list of undefended suit. GA number 5 of 2024 is disposed of. Full stop. Let the matter up. Yes, what about the
places it any day after reopening?
This judge's brief of document?
Lord, we shall prepare.
Full stop. The plaintiff is directed to file the judge's brief of document within 2 weeks after puja vacation. Within 2 weeks after puja vacation?
1 week after. As and when your lordships will have business permits.
Within 1 week after puja vacation. Okay, date. How many witnesses you are having?
And at least 1, maybe 2. Let the first witness be there, my lord.
Huh? What distance? Any chota mein? 345. Dispose of project. 20 November. 20 November at 3:45 for witness X. Next, dispose of an affidavit.
Lord 6, I appear for the plaintiff, my lord. We were to file a reply. I'm filing my reply, my lord. And my lord, I'll be praying, my lord, that the matter may be fixed for hearing after vacation.
Football Association.
Yes, my lord. My lord, just my lord, one more prayer before my lord. Your lordship, or as per my the order dated August 7, 2024, my lord had granted an interim order. Your lordship may kindly extends the same.
Shall be abide by the result of this application.
Yes, but there's no date specific. Just
This application.
very well, then my lord.
So this application is pending.
Very well.
You are appearing for the?
No, she's with me.
So what you have filed?
The affidavit in reply.
They have filed the opposition.
They have served as the copy of affidavit in opposition.
The opposition have filed me.
I believe he is not appearing today, my lord.
नहीं.
Yes, sir.
So and so appearing for the plaintiff. Then appears for the defendant. Plaintiff has filed the affidavit in reply. Let that same be kept with the record. The counsel for the plaintiff submits that the defendants have served the copy of the affidavit in opposition, but the same is not on record. The department is directed, if any affidavit in opposition filed by the defendants, be placed in the record. This is the matter on 19th November 2024 under the heading New Motion.
Extremely grateful, my lord.
Not new motion, adjourn motion. Next.
Lordship, I prepared a short list of dates, Lordship.
Which was the other side?
The side is
Injunction application. Other side is appearing?
no, Lordship. The other side is not appearing in this matter. I'm praying for an injunction in the ad interim.
Yes.
Lordship, I am the plaintiff in this matter. I have made a franchise, an agreement with the this thing, and the agreement where I have been allowed to run my city mart. These are the photographs of the place where I have been running my.
What is the suit for?
Suit for is for the movables I have got inside there. He is not allowing me to take it out. These are ready-made wares and other products. I'm praying for status quo because he is the landlord of the premises. I had taken on the rent on this premises. After all of a sudden, when I gave him a notice that I don't want to continue in the premises, that was on 22nd of November. On 30th, he goes and locks the premises up and does not allow my goods to be taken out. And after that, I have negotiated with many times with him. I have gone to the mediation center, but he is at certain this thing we had to make complaints to the police as he's opening the locks because the locks has been put by him. He is taking out the ready-made movable assets of the of mine. So I'm praying for if they could the status quo order can be passed or this thing, whatever is lying this thing, let him. I'll serve and he can come and. Lordship, you'll see the photographs here.
Page 180 টা দেখান যেটি আমরা বলেছি last annexure.
Page 180, Lordship, if you see it.
Last annexure.
We have made a complaint to the police even.
180 তে 106 notice. 180 তে 106 notice এ reply আমরা দিয়েছি। আর এখানে police
He has given me a notice under 106. I have replied to that in page 180.
187 এ আমরা police কে
So this is premises for the business purpose?
Yes, sir.
Then?
So I am paying, he has put a lock and key in the premises. My goods are inside here, and he is opening the locks, and whenever he wants, he can take it out. I'm just praying for status quo as of today.
Is there any agreement between you?
The agreement was there. He himself cancelled that agreement. That agreement is in page.
It is not the commercial.
Lordship was last time when I was presenting, he was wanting this thing, but then Mr. Banerjee said that it is not.
Yes. Then
106 notice is you want it to.
They have given a notice under 106. That is why it has been ousted from the commercial jurisdiction of this court.
that is in dilemma. Okay, no problem.
Agreement with the page.
Agreement is?
There is a
Agreement, agreement is in page 43, Your Lordship. And the termination notice, that is on.
So you entered into an agreement, tenancy agreement on 19 July 2018.
Yes, Lordship.
And you are running the garment shop.
For 9 years, I had got this
For the
agreement.
garment shop.
Garment shop.
This is for the for how many years? 9 years.
For 9 years. All of a sudden, he terminates this agreement.
And when he had terminated?
On 20 on
20th আমরা চিঠি দিলাম 22nd
on the চিঠিটা
When he has terminated?
Yes, Lordship. On 30th of November, he has terminated. 2022.
Where is that?
Give me the
connection with it 160 page 160
page 160, Lordship.
When you have paid the last rent? 160?
160, Lordship. In the second paragraph, the agreement already stood terminated. This is his letter. Then we further negotiated with him.
So this is the termination.
Yes, Lordship.
2022. And up till as per 2018, 9 years.
9 years. And I have, after that, we made an oral agreement.
When you paid the last rent?
I have paid him the electricity charges in the 10th of April 2020.
Last rent when you have paid? What was the rent?
Rent was on the basis of 9% of the this thing sales.
When you have last paid?
28 lakhs. Is it in the list of dates, Lordship? List of dates.
How much amount you have paid as a security deposit?
15 lakh 60,000 rupees.
How much?
15 lakh 60,000 rupees.
15 lakhs.
paragraph 20 বলা আছে আমার paragraph 20 টা
What was the monthly rent?
3 lakh 90,000 rupees.
Monthly rent?
Monthly rent.
paragraph 20
3 lakh?
90,000
per month?
per month.
Yes, then?
And the Lordship was asking me how much I have paid. This is in page list of dates, page 5. It is the amount is 28 lakhs rupees I have paid. Page 5, 29, 11, 22.
Then?
After that, he put a lock on the main gate.
After 2022, he has put the lock. Now you are coming after 2020.
There was a negotiation going on, Lordship.
Where
The
is the
negotiation,
negotiation?
and I have paid him further amounts for electricity dues, and he says that he will allow me to operate again, or to allow me to take out my goods. That the negotiation broke down. I'm only paying for status quo now.
152 of last date 5 lakhs rupees.
Page 152 is the
last payment I have made.
20.
আপনার উপরে যে 146 এ 180 তে আমরা লাস্ট চিঠি করেছি এই চিঠি আমরা লাস্ট দিয়েছি, তারপরে আমরা এসেছি দিয়েছে এভিকশনের নোটিশ, আমরা এভিকশন নোটিশ করে এখানে তো এখানে তো কাউন্ট হবে না, অত জন্য প্রবলেম করছিল, অত জন্য
eviction notice দিয়েছে তো জুনে 20।
তারপরে আমরা রিপ্লাই করেছি আগস্টে, শুট ফাইল করেছি সেপ্টেম্বর, এটাই বলবো কি ওরা আমাকে 106 নোটিশ দিয়েছে, 106 নোটিশ দিয়েছে,
এটা আছে।
এটা 106 নোটিশ ওরা আমাকে দিয়েছে জুলাই মাসে, 27 জুলাই, আমি তার রিপ্লাই করেছি 26 জুন, আমি এটা করেছি 28 অগস্ট, তারপরে শুট ফাইল করেছি 3rd of September, মিডিয়েশন ইন দ্য মিড টাইম ছিল, মিডিয়েশন হয়েছিল 19th অগস্ট, দেখুন বলে
Yes.
Lordship, he had given me a notice only this thing in 27th of June 2024. And then I replied 106 notice. Then I replied to that this thing. And then I filed, that was in August. In September, I filed this suit.
mediation.
And in the meantime, I had gone to mediation center, which that failed.
They are not. Okay. জিনিসটা খুলে নিয়ে নিচ্ছে, এই ডেটটা এটা পুলিশকে চিঠি করেছি আর ফটোগুলো দিয়েছে ওরা চুরি করতে চায়।
Plaintiff has filed the present suit. Plaintiff has filed the suit. Praying for a decree of rupees 2,01,48,484 along with interest at the rate of 18% per annum and allied prayers. Plaintiff has also filed an application in GA1 of 2020 praying for ad interim injunction. The plaintiff and the defendant have entered into an agreement for tenancy cum lease on 19th of July 2018 for a period of 9 years. 9 years. At the monthly rent of rupees. What was the monthly rent in the agreement?
3,90,000 rupees.
At the monthly rent of rupees 3,90,000 per. What was the surety amount?
15,60,000, Lordship.
Plaintiff has also paid a security amount.
Page 52 is this thing statement.
Rupees 15 lakh.
15,60,000.
15,60,000. The plaintiff had started business with the
and furniture
and started. Huh? Started business and the premises.
Our claim is in paragraph 20, Lordship. Page 31.
Due to the pandemic COVID-19, the plaintiff was not in a position to run the business, and due to which there was shortfall in the reduce the shortfalls and reduce the food due to pandemic COVID-19, the plaintiff could not able to run the business, due to which the plaintiff has suffered severe business loss. On 14th of July 2022, the plaintiff has expressed a desire to the defendant that the plaintiff is not able to run the business and he will vacate the premises. On hearing the intention of the plaintiff, a meeting was held between the plaintiff and the defendant
And the defendant had agreed that the plaintiff should continue with the said business and will pay only 9% of the monthly sale from the showroom that is about rupees 3 lakhs per month. 3 lakhs per month. Full stop. The plaintiff has paid a lump sum amount of rupees 28 lakhs 20,609 to the defendant, being the 9% of the total sale with effect from 20th July 2022, 29th November 2022. In the month of November 2022, the plaintiff has informed the defendant that the plaintiff is not in a position to continue the business and he will vacate the premises with effect from 1st of December 2012. Full stop. The defendant intending to operate the said business, and as per the meeting held between the plaintiff and the defendant, the plaintiff agreed to continue the business by paying the monthly rent of rupees 3 lakhs from the month of December 2022 to May 2022 to the month of 2023. May 2023. Full stop. It was also agreed between the parties that the plaintiff will pay rupees 20,66,834 to the defendant on account of the arrears of rent. On account of arrears of full stop. On 29/11/2022, the plaintiff has paid an amount of 5 lakh to the defendant as per the meeting held on 29/11/2022. On 30/11/2022, the defendant has taken possession of the said premises and put the said premises under lock and key. The respondent has also started threatening the plaintiff and started taking out the materials from the said premises. The plaintiff has also made several complaints to the police authority, but the police authorities have also not taken any steps. Subsequently, the defendant had issued. What is the date of the notice of 106?
Issued
notice on
27th of June. And Lordship had asked me when I had paid last. I paid
Transfer of Property Act by terminating the contract. The plaintiff had, on receipt of the notice, the plaintiff has served a reply, but in spite of this, neither the defendant has allowed the plaintiff to take out the materials from the premises, nor the defendant has allowed the plaintiff to continue the business in the said premises. For responses from the plaintiff submit that the defendant is alienating the property, is taking out the all materials from the shop of the plaintiff and is selling the same in the market. Counsel for the plaintiff prays for identity injunction, restraining the defendant, restraining the defendant for selling, dealing, or disposing of the materials lying in the said premises. Heard the learned counsel for the respective counsel for the plaintiff review the materials on record. The plaintiff and the defendant have entered into the premises in the month of July 2018, and subsequently the plaintiff had started business in the said premises. The plaintiff has also paid the monthly rent to the defendant. After the COVID-19, the defendant and the plaintiff was not in a position to pay the rent due to severe loss in the business, and requested the defendant that he will and informed the defendant that he will vacate the premises. But as per the request of the defendant, the defendant continue with the said premises with the agreement that out of the total sale consideration and out of the total sale of the input materials of the shop premises, comma, the plaintiff will pay the 9% of the same, that is about rupees 3 lakhs per month. The plaintiff has paid for some time, but in spite of the same, the plaintiff found that plaintiff is not in a position to run the business, and again inform the defendant that he will vacate the premises. Full stop. In spite of settlement between the in spite of settling the dispute between the plaintiff and the defendant, comma, defendant has taken the possession of the said premises and put the premises under lock and key and started selling the materials from the said materials of the said shop room without the consent of the plaintiff. Considering therefore this court final, plaintiff has made out a prima facie case and variance of convenience and inconvenience, and no, and accordingly the parties are directed to maintain status quo with regard to nature, character, and possession of the premises in question, and the defendant is further restrained from selling any materials from the shop of the defendant till 14th of November 2024. The plaintiff is directed to serve the copy of the print, application and the document to the defendant immediately, and to file affidavit service on the next date by the returnable date. This is the matter on 14th of November 2020. Yes, next.
Much obliged, Your Lordship. My lord, item number 6, my lord. Previous matter, my lord, I am praying leave, my lord, to file my affidavit in opposition, my lord. My lord, they have filed a reply, my lord.
I already passed some order.
Item
My lord,
I appear for the plaintiff, my lord. So I had filed my reply, he didn't appear.
my lord, I am filing my opposition, my lord, within time, my lord.
Then I have to change my order. You file in the department. I already passed an order. You serve the copy, you're not
Yeah, my lord, I have already served copies.
You file the affidavit in the department. Filed in the department will send it. Yes, next. Call the matter.
My lord, we've, so far as the suit is concerned, my lord, we've obtained leave under clause 12 that your lordship has been pleased to, and order to rule 2 as your lordship has been pleased to grant us these 2 leaves. My lord, may I just briefly tell your lordship the facts on the basis of which we are seeking to move this interlocutory application, my lord, without notice.
Ad interim.
Ad interim, without notice. My lord, kindly see the cause title once. My lord, a company is the plaintiff. The first defendant is also a company. The second defendant is an individual. Third is a company. And the fourth is an individual. Now, my lord, the subject matter of the suit relates to 366 decimals of land. Now, my lord, admittedly, the plaintiff is the owner of the land. Now, my lord, the plaintiff had entered into an MOU. If your lordship will kindly take the trouble of once coming to page 31. My lord, this is where it all started.
31.
31, my lord. Your lordship will find.
What is 24?
That is the previous agreement. Previous agreement.
Yes, 31.
So, about 31, your lordship will see the first defendant. We had entered into an agreement by which the first defendant had agreed to initially purchase the property. There was certain understanding. So, this is just a MOU.
So, you are the seller?
I am the seller.
D1
the defendant number 1 is the purchaser.
Correct.
Now, my lord, what had happened that he had admittedly paid some money under the memorandum of understanding. A substantial part of the money, in fact, was paid under the memorandum of understanding. Now, my lord, we had also entered into a power of attorney. We had, in fact, granted him a power of attorney, which your lordship will find at page 38. On the same day.
Yes.
It's a registered power of attorney. Now, my lord, what we did is.
To the defendant number 1.
To the defendant number 1. in fact, my lord, if your lordship will kindly comes to page 39, your lordship will find it was given to the defendant number 1, who was then represented by the defendant number 4, who was nothing but his director of the defendant number 1 company. Now, under this memorandum, under this power of attorney, we had authorized him to sell the land on our behalf. But if your lordship will see what we did, my lord, just a few clauses of the power of attorney which is relevant for our purpose right now. My lord, if your lordship will kindly come to clause 11 once at page 47. Because what we are trying to say is that, my lord, to cover the point of section 202 of the Contract Act, that by this power, he did not get any interest in the property. So he cannot say that this is an irrevocable power of attorney. Anyway, he does not. My lord, kindly take para 11 once, page 47. It is expressly stated that the power of attorney does not create or constitute or assume any kind of transfer, enjoyment, or making any point in favor of the attorney, and declare that the said attorney shall not hereby obtain or have power for development work of such property. My lord, also kindly take the trouble of looking at 13 and 14, the two clauses at page 48. 13, my lord, indicates that the power given without consideration and no interest or right of the attorney is created in the property, specifically mentioned. Now, my lord, kindly take 14 months. Be it noted that this revocable power of attorney, it's specifically mentioned, revocable power of attorney, is being granted in favor of the attorney without any consideration, no right and interest, such and such, then, which is subject to the power of attorney in that person, such and then, my lord, kindly skip one line and then come to, and further that the entire sale proceed, if any arising out of any part of the scheduled property shall be deposited in the bank account of the principal, irrespective of any condition. So if he sells on my behalf, the deposit has to be in my account. My lord, immediately after grant of the power, we realized that his intentions were otherwise. 6 days after granting the registered power of attorney, we revoke it. Now, my lord, kindly come to page 58 once. Registered revocation. My lord, kindly make a note of the date, 6th of January 2024, and the power of attorney was 29th of December. By this, I revoke the power of attorney by a registered instrument, not just revocation. Yes. Then, my lord, kindly take page 67. This is a letter by which I inform him that by a registered instrument I have revoked your power. So you have no authority to represent me so far as this land is concerned. Letter dated? Page 67, letter dated 10th January 2024. Yes. Kindly see on the top left, my lord, postal receipt. Now your lordship, another surprise comes. But kindly turn to the next page. Your lordship will find, your lordship will be surprised to note that this is the order of a civil court, ex parte ad interim order of a civil court dated 1st of March 2024. Now, my lord, kindly come to the middle portion of this page. Who is the party? They, the defendant number 1. They, the defendant number 1 is the plaintiff there. Now, my lord, interesting, kindly see this. Kindly see the middle. No, the judge is right. You all have not given the body cross title. No? How will anybody know? They have the certified copies. I have understood the logic why it comes. Naturally, the first, actually, trial court orders that cost title is not mentioned on top.
No.
It's there in the next page. It is there in the. Now, my lord, kindly come to the middle portion once. My lord, there is a paragraph which commences with the word now.
Yes.
Towards the middle of the page, your lordship. You see, now it is. Has your lordship found that, my lord?
Specific
Yes,
allegation.
yes. Specific allegation of the plaintiff that after the execution and registration of the general power of attorney, just after 7 days, the defendant illegally revoked and cancelled the registered general power of attorney without any consultation to the plaintiff by illegally executing a registered deed of revocation. So, my lord, when he goes and files the suit, his suits proceed on the basis that the revocation has been cancelled by a registered deed. So, he is aware on 1st of March, I cancelled it in January. Despite this, your lordship will be surprised to note the operative portion of the order at page 69. Yeah, of course. Page 69, the operative portion of the order. My lord, I do not wish to read it in public, my lord. Kindly, my lord, consider this. Ad interim.
Decree granted.
No, more than I ask for A, I get Z. On a registered revocation of power of attorney.
Yeah.
Is at liberty to sell transfer. Now, my lord, naturally, I go in appeal from this order. My lord, kindly come to the next page. At page 70. My lord, this is a fraud of a different magnitude altogether. My lord, kindly come to page 70 now. My lord, I go in appeal. Now, my lord, these suits are filed in the lowest possible court with the minimum court fee. I don't know how these suits are entertained. So now I don't have a choice but to go before the district judge in appeal.
No. Which court? It is
My lord, if your lordship will see.
civil just senior division or junior senior division?
No, my lord. But if the court fee is below 1 lakh, no, below 60,000.
Correct. No,
Then it goes, the appeal goes before the district judge.
that
So my lord, so now kindly come to page 70, the appeal court's order. So appeal court naturally state the order. Your lordship will find the page 71. Page 71, the operative portion.
Interim order page 70.
Now, my lord. Now what he does is, now I make searches. So I had sufficient reasons to apprehend that he is playing foul.
Yes.
Now, my lord, lordship will kindly see. What he does.
Yes.
On 7th of March, he executes 3 deeds. All amongst them, his alter egos, companies where he has control and shareholding, and he has control of ownership and management. What he does, your lordship will find there are 3 conveyances that he executes, transfer deeds. One is at page 72, the second is at page 105, and the third is at page 145. 3, 72, 105, 145.
Yes.
The first deed, he transfers it to defendant number 3, which is a company owned and controlled by the defendant number 2.
Then
72 is the deed which is transferred to defendant number 3.
Yes.
105 is also transferred to defendant number 3.
Yes.
And 145 is transferred to defendant number 2, which is an individual.
Yes.
And my lord, your lordship will find more or less at the same period, 7th of March.
So had he deposited the amount in your account?
No, nothing. And in any event, my lord, once I have revoked his power and the revocation which he accepts. And my lord, kindly see only one last paragraph in the deed of conveyance, the first conveyance which starts at page 72. My lord, kindly come to one paragraph. My lord, at page 85, which is the continuation of the deed. which starts at page 72. Well, this is the most gross and the most apparent ex facie act of fraud when you know you have gone to a civil court saying that it has been revocation. Then based on that power, how are you selling on the 7th of March? Well, kindly see the paragraph 85. I stand corrected. Page 85, kindly see the third recital.
Yes.
Now, my lord, he's executing on my behalf. Now, who is executing, your lordship will find. Based on the power of attorney, he is executing. So now my simple question is that if the power has been revoked, so where on what basis are you executing the deed on behalf of the original owner? Now, my lord, kindly take the first recital which starts at page 85, whereas Ravalgaon, which is the plaintiff, being an absolute owner such and such, Intag agreed to sell such and such, entire consideration MOU, then executing. My lord, kindly see the
Based on the GPA.
Yes, based on the GPA.
Correct.
So he could not have done that. And my lord, he refers, he gives the date also. General power of attorney dated 29 December 2023. And next para you see MOU as well as general power of attorney.
Correct.
So
yes.
So, my lord, at this stage, my lord, all three are the same, identical. At this stage, my lord, kindly come to paragraph. I stand corrected. My lord, page 20. My lord, at this stage, my lord, I would respectfully be praying for an order in terms of prayer C. No further transfer. My prayer in the suit is cancellation. Cancellation of the 3 deeds. So I'm asking for prayer C to start with. No further transfer.
Yes.
And the fraud, my lord, if your lordship, I may indicate, my lord, the fraud is pleaded at paragraph 27, page 11. That your lordship, that is finally decided at the hearing. But right now I'm saying that you cannot create any further interest on this property.
What will happen to the civil court?
Who is his civil suit? We are contesting rejection of plaintiff application filed. My lord, even the suit is ex facie not maintained. It's a declaratory suit. How do you maintain a declaratory suit? And who are you to maintain the suit? At best, he could have asked for specific performance of the MOU. At best, nothing more than that. And my lord, your lordship is aware, my lord, this suit has been filed only for injunction. Once injunction is gone, that's the end of the suit. But no purpose will be served. These are all injunction-based suits. And my lord, I've already got stay in the appeal, in the first appeal. I mean, miscellaneous appeal from the interim order of injunction. Yes, absolutely.
Have you enclosed the plaint? No.
My lord, have you enclosed the plaint? My lord, the reliefs are there. Reliefs are set out. If my lord will, if your lordship will kindly come, the plaint reliefs are set out at paragraph. Well, I think it's, but I'll still give your lordship the praise in the suit. My lord, page 173 is the plaint. My lord, the prayers your lordship will find in the interrogatory application. Kindly see the prayers at page
Got it.
16, para 34. My lord.
Suffering for the plaintiff. Plaintiff has filed the suit for declaration of the purported deed of conveyance, all dated 7th March 2024, as unenforceable and null and void. and allied prayers. The plaintiff has filed the present application, being GA1 of 2024, praying for identity injunction. The plaintiff and the defendant number 1 entered into a memorandum of understanding on 29th of December 2023 with respect of several plots of land to which the plaintiff is the owner of the said plot. Subsequent to registration of the memorandum of understanding, the plaintiff has also executed a registered general power of attorney in favor of the defendant number 1. Subsequent to registration of the general power of attorney, the plaintiff came to know that the defendant is violating the terms and conditions of the memorandum of understanding as well as the general power of attorney. Accordingly, on 6th of January 2024, the general power of attorney was cancelled by way of registered deed. The cancellation of the general power of attorney was duly informed to the defendant by a communication. On receipt of the said communication, the defendant had filed a suit before the London Court of Civil Justice Senior Division
Civil Judge Senior Division 7th Court, Mile.
7th Court, Alipur, alleging that the plaintiff has illegally revoked and cancelled the registered general power of attorney without any consultation of the plaintiff and without any consultation with the defendant. The London Civil Justice Senior Division 7th Court, Alipur, by an ad interim order dated 1st March 2024, restrained the plaintiff herein, who is the defendant in the said suit, from giving any effect to the deed of revocation of power of attorney dated 6th of January 2024. 6th of January 2024, and given the liberty to the defendant number 1 herein to sell, transfer and alienate the suit property in favor of the third party by the authority given by the plaintiff herein to the defendant on the basis of the general power of attorney dated 29th of December 2023. When the plaintiff herein came to know about the impugn order dated 1st March 2024, the plaintiff has filed an appeal before the London District Judge, South 24 Parganas at Alipur, and by an order dated 21st of March 2024, the London District Judge had passed an order of stay of the impugn order dated 1st of March 2024. London Counsel for the plaintiff submits that the stay is still continuing and the appeal as well as the suit is pending before the London Court. The counsel for the plaintiff has brought the attention of this court to 3 deeds, 3 conveyance deed entered by the defendant with the defendant number 2 and 3 with respect of the property in question. The defendant has entered into the said deed of conveyance with the defendant number 2 and 3 on 7th of March 2024. That is only after the order of stay obtained from the Learned Civil Judge Senior Division, 7th Court, Alipur. Learned Police. Counsel for the plaintiff. Police. Counsel for the plaintiff submit that the plaintiff has cancelled the registered power of attorney by way of registered deed, and as such, the defendant has no power to execute any conveyance deed with respect of the property in question. But in spite of the same, the defendant number one is selling the property, and the plaintiff also apprehend that the defendant number 2 and 3 who have entered into a conveyance deed with the defendant number 1 may also further transfer the said property to some other third party, and accordingly a case for identity police.
Nature and character এর কথা বলা আছে?
In the memorandum of understanding dated 29th of December 2024, it is categorically mentioned that no, in the general power of attorney. In the general power of attorney dated
29th December
2023, it is categorically mentioned that this power of attorney does not create or constitute or assume any kind of transfer, enjoyment, or making any profit in favor of the attorney, and they further declare that the said attorney shall not hereby obtain or have power to develop power for development work on such property. In the said power of attorney, it is also categorically mentioned that the power of attorney is irrevocable and is being granted in favor of the said attorney without any consideration, and no right, title, and interest is created in favor of attorney on the property which is subject of this power of attorney, and that the said attorney shall not hereby obtain any right to make construction and development work on the said property, and further that the entire sale proceed if any arising out of any part of the scheduled property shall be deposited in the bank account of the principal irrespective of any condition. Counsel for the plaintiff submit that though the plaintiff has revoked the power of attorney, but taking the shadow of the order passed by the Learned Civil Judge Senior Division 7th Court, Alipur, dated 1st of March 2024, the defendant number 1 has entered into a conveyance deed with respect of the sum of the property with the defendant number 2 and 3, but has not deposited any amount in the account of the plaintiff. Consider the submission, considering the above fact and circumstances, this court find that the plaintiff has made out a prima facie case and balance of convenience and inconvenience in favor of the plaintiff. This court find that at this stage the defendants are not restrained from entering into any further deed, any further agreement, deed, or any kind of things with any third party with respect of the property in question, the plaintiff will suffer irreparable loss and injury and will loss and injury. Accordingly, the defendants are restrained. Defendants, their men, agent, assigns are restrained from transferring, selling, alienating, encumbering, or from dealing with the subject plot of land in any manner whatsoever till 20 November 2024. The plaintiff is directed to serve the copy of the application, plaint and documents to the defendants immediately, and to file affidavit of service on the returnable date.
Great. Great.
Next.
I am opposing this application, my lord.
There are three applications, I believe. Mr. Doctor is opposing all.
No, lordship had the occasion to hear a connected matter. It's item number 44, no? 43 and 44, where Mr. Mukherjee was, my lord, addressing on the Order 7 Rule 11 application. There are two suits, CS 176 and 177. My lord, 43, item 43 is, my lord, applications 43 and 44 in connection with 176, which lordship was hearing the other day. He could not complete lordship's last order records that. So far as this is concerned, it's in the same line. So, my lord, either he can continue with that or, my lord, whichever way.
Item 9 is connected with the item 43, 44.
Because it's similar, my lord. There are two suits. Item 9 is
Plaintiffs are
177.
different. Defendant is the same. Both suits are for recovery of money.
Applications are
In
also
both
same.
suits, they have filed an application for final judgment, and in both suits, I have filed application for rejection of plaint. Only in this item number 9, there is an additional application GA number 3 for extension of time to file written statement.
In addition.
In addition, because in item number 46, that application has already been allowed. In item number 9, it has not been allowed. So that
allowed pending the Order 12 Rule 6, Order 7 Rule 11.
Yes, depending on the outcome of those applications. If my lord wants, I can start with item number 9. I would want to press my Order 7 Rule 11 application before my learned.
43, 42, 43.
43, 44.
43, 44. Who is appearing?
My lord, same. We are appearing, my lord.
Same.
And lordship was hearing 43, 44 the other day. He started with his Order 7. Yes, issues are same.
Yes.
Can be taken up together.
Yes, in fact, the last order was passed in all
the matters. Yes. That is how the last order was.
क्यों अलग-अलग हो गया?
For our benefit, possibly.
Item number 9, so and so appearing for the plaintiff, so and so appearing for the defendant. Counsel for the party submit that item number 43 being CS 176 of 2022 and item number 44 being CS number 176 of 2022 is also connected with item number 9, that is CS number 177 of 2022. In all the three applications, all the three suits,
Two suits.
No.
43 and 44 are two separate applications in one suit, which is CS 176. And item number 9 is, my lord, three applications. Yes.
So, in both the suits, the plaintiff have filed an application
for summary judgment.
And the defendant has filed an application for rejection of plaint. In CS number 177, the defendant number 1, defendant has also filed an application for extension of time to file return statement. This could find that all two suits are interlocutory are interconnected, and as such, this court is of the view both the suits and interlocutory applications shall be taken up for hearing together. In view of the above, CS number 176 of 2022 and CS number 177 of 2022 along with all connected applications be fixed and be listed on time, then you will go December.
No, my lord, November, any day, my lord, regular.
I am fixing in November and adjourn motion when fix on 13th of November 2024 under the heading adjourn.
My lord, since lordship is keeping it under the heading adjourn motion, kindly provides for one, my lord, liberty. In the event, my lord, the plaintiff chooses to use any affidavit to their application for extension of time to file written statement, I'll do that in the meantime.
In the meantime, if the plaintiff intend to file an affidavit in opposition in connection with GA number 3.
GA3, my lord. IA
CS 177 of 2022, the plaintiff may file affidavit in opposition within 2 weeks. Then again.
No, makes it, my lord, within, my lord, 8th of November, my lord, if 8th of October, my lord.
By 8th of October 2024, reply if any be filed by 7th of November 2024, list the matter on 13th November.
I'm grateful.
My lord.
Next.
I have application, my lord, for appointment of a local commissioner in a suit for eviction. My lord, one of the grounds that I have pleaded in the plaint is that, my lord, there is construction made by the defendant in the suit property.
My lord, I have been requested by the respondent advocate to not to take up the matter today.
But GA3.
GA3.
But GA3 no affidavit. You
No affidavit I have received. I have filed the reply. Maybe the affidavit is not filed in court. That may be. But we have received the affidavit and we have filed our reply. This is in a sense, my lord, urgent, because, my lord, I am only seeking for appointment of a commissioner so that, my lord, my suit can be made ready for hearing, because this one of the grounds is that he has made
filed by plaintiff.
by plaintiff.
So defendant has to file affidavit.
Has already filed.
But what has happened?
Yes,
It is not on record.
yes, may not be in the record, my lord.
It is not on record, and this court has directed department. Department sent the report that no affidavit is filed in the department also.
It should be a ground for allowing the
My lord, I am not appearing in
Okay,
this matter.
not
My lord,
today.
kindly take it up
Not today.
tomorrow. I am grateful.
Next.
My lord, I am for the defendant, my lord.
I am for
my
the
application.
plaintiff, my lord. I am led by Mr. Subhashish Sarkar. He is on leave before another bench, my lord. I am led by Mr. Subhashish Sarkar. He is on leg, my lord.
He is on leg.
Kindly, my lord, I am praying for not today.
Not today. Next.
God bless, my lord.
Grateful, lordship. This is the application for substituted service with all the service on different numbers 1 to 4 has come back. Yes.
But I am
1 to 4.
5. I have not received a copy of this application. It's indicating that at the outset, the paragraph is
Substituted service upon the different number you are appearing for?
1 to 4.
5.
1, 2, 3, and 4, right?
1, 2, 3, 4, and 6. So 5 is appearing.
5 is appearing. 1, 2, 3,
4 and 6.
4 and 6. 5 is appearing.
Why? Why it has not been served?
Millard, it came back, Millard, on numerous occasions.
Where is
Millard,
the
page
report?
6.
Where is
Kindly
the-
have a look at page 6, Millard.
Page 6.
This is as per the writ of sum.
You not serve the copy?
Copy
Serve the copy. Arey, give the copy.
Arey, now, bhai, amar
The original side.
copy this ticket. I am giving up. Not necessary. Yes. Millard, kindly have a look at paragraph 6, paragraph 3, page 6. Kindly look at Millard. So far as 1 is concerned, and 1 and 2 is refused, 1 Millard, as per the receiver addressee left without instruction. We are listing in the same premises. And Millard, defendant number 3 not present, 4 not present, 5 served, 6 Millard could not be served as a defendant not available. As per the room receiver's addressee left without instruction. Now, Millard, I am also praying.
Yes.
Lordship was pleased enough. I am the daughter-in-law, Millard. Suit for partition. So, Millard, first of all, summons Millard, substituted service Millard on these defendants.
Where they are residing? Alipur?
Yes, Alipur. Those are Millard, Alipur, and also Grastin Place, Millard.
Office space.
Office space.
Grastin
Alipur.
Place.
Yes.
Grastin
Any
Place.
locally having
Local
reasonable
newspaper.
Yes, Anandabajar and Telegraph.
Telegraph.
Both the Millard application and the Millard suit Millard. Because application they are also not appearing. Lordship can't dispose of without it has
What
to
is
be
the application?
Millard for injunction. Lordship has protected me, Millard, and also appointed a receiver. Order to down.
So and so appearing for the plaintiff, so and so appearing for the defendant number 5. Plaintiff has filed an application being GA2 of 2024, praying for allowing the plaintiff to cause substituted service upon the defendant number 1, 2, 3, 4, and 6 by way of publication of advertisement in the daily newspaper. Counsel for the police. Counsel for the plaintiff submitted. After filing of the suit, the plaintiff has taken appropriate step for lodging of writ of summons, and subsequently the same was issued to the office of the sheriff for service. Neither the summons was served upon the defendant number 1, 2, 3, 4, and 6, either through the serif or through the postal service, and the same was returned with the endorsement that addressee left without instruction, except the defendant number 5, as the defendant number 5 has received the writ of summons. Consider the submission made by the consul for the plaintiff, peruse the service report as well as the postal report, wherein it reveals that the writ of summons could not be served upon the defendants number 1, 2, 4, and 6, as it is mentioned that the addressee left without instruction. Considering the submission of the plaintiff and after perusing the report, the plaintiff is allowed to pause publication.
Lord, prayer A, Miller.
The prayer A of the master summons, prayer A of the notice of motion, prayer A of the petition.
Millard, paragraph both Millard the writ of suit as well as the application. They're not appearing. Lordship will provide. Both suit and the
Proceeding counsel for the plaintiff further submitted. The plaintiff has also filed an application being GA1.
GA1. Injunction and receipt.
Praying for interim order. This said application also could not be served. According the plaintiff prays for publication of the notice of the suit as well as the interim application being GA1 of 2024. In view of the submission made by the counsel for the plaintiff is allowed to publish.
So in Bhaskar, there Millard, Hindi
publish
speaking
the
people.
notice of the writ of summons as well as notice of the GA1 of 2024 in the English daily newspaper, the Daily Telegraph,
Lordship.
Telegraph, and the Hindi
Dainik Bhaskar.
Hindi newspaper, Dainik Bhaskar. Full stop. The plaintiff is directed to take appropriate steps within a week after the puja vacation. Wait for publication of the notice in the above mentioned paper publication in the above mentioned papers.
Grateful.
My lord, before
GA number so display.
before your lordship rises, my lord, may I mention item number 5? My lord, I am appearing on behalf of the defendants. My lord, I understand this application has been disposed of. My lord, directing the suit to be transferred to the undefended list.
I was there, my lord.
Now, firstly, my lord, it's our fault that we were not there. There was, my lord, some confusion about a notice saying that, my lord, no adverse order to be passed. In any event, no. My application, the defendant's application for revocation of leave is pending. My lord, kindly recall the order and kindly hear out the application, my lord.
Recall of the order dated order?
Today, my lord, this. He cannot have any say.
No, of course.
It's between the court and the defendant.
Who has taken the order?
My lord, what happened was, your lordship has already, in fact, decided that point in the argument of 31st July, and my lord, they have already preferred an appeal.
Could not have been.
Okay, whatever it may be, as per the resolution they have taken.
A resolution is something, my lord.
The
I cannot
application
stand
is
in.
also pending.
Not today, correct. Not today. Not today.
Lordship.
My lord, and my lord, pendency of an application for revocation is not a ground not to file the written
I am
statement.
not passing any order, not today only. Let us.
Lord, item number 6 will
Lordship in item number 4. Lordship is in item number 4.
With the senior.
My lord, item number 6. Yes, my lord, item number 6.
Yeah.
My lord, my lord, plaintiff has filed their affidavit in reply. That is although, my lord, not within that time. My lord, my affidavit in opposition, my lord, is within that time and serve also within that time. But my lord, I am told by the department today that, my lord, endorsement of leave is required at the back seat. Otherwise, my lord, they will not accept in the department.
You do one thing, you keep with you. I already called for the report from the department.
Yes.
Report be submitted. On that day, you bring that, I will take on record.
No problem.
Well, Lordship already has fixed the date for hearing, my lord.
So what? You have served. I have
Yes.
taken. You see, the court is not going to hear read your affidavit in opposition.
Yes.
Your opposition will be taken into consideration at the time of hearing of the application. You come on that day.
Yes.
Because other parties have filed the reply.
Yes,
Come
my
on,
lord.
I will take on that.
Lordship, item number
I pass an order on directing the
Lordship, in item number
to give the report whether the affidavit is filed or not. If they will say not filed, then you file it. I will take that.
Lordship, item
Come on
number
that. When the matter is not calling, why you are not appearing before the court?
Well, there was a confusion.
Okay, no problem. No problem. I will.
Well, I'm not impression that will not put in.
Okay, come on the next date. I will take that. Yes.
Lordship, item number 4 of the today's list, Lordship, an order was passed, Lordship, and the
After
matter was
vacation.
fixed. I am for the plaintiff, Lordship, and the matter is fixed after vacation, Lordship. There was a resolution on behalf of the bar for a felicitation of Lordship IP Mukherjee, Lordship, so we couldn't appear. It's of grave emergency, Lordship. Admissions are going on, Lordship. It's a suit of defamation, Lordship. GA application has been filed, Lordship. Lordship,
there is an urgency. Why your persons are not appearing before
Lordship,
the court?
Lordship, there was Lordship, just because there was a resolution, Lordship, we couldn't appear. Only
not pass any adverse order.
Lordship,
next
just
after
just
vacation.
praying. Just it is the high time, Lordship. The vacations will be on, and in the meantime, admission. This is a peak time. I'm representing the university, Lordship.
On that when the matter was called.
Lordship, only recall the order, Lordship, and fix the matter here for 5 minutes, Lordship.
Yes,
please, Lordship.
Number 14.
Lordship,
Application for amendment.
Lordship, in item number 4.
Lord, may I just make one request? Your Lordship?
Time.
Lordship. Arey yaar. नहीं उसको कौन बोला मेंशन